Hello, everyone, and welcome back to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and to practice before the United States Supreme Court. And I hope today is the day I earn that subscription. For today's story, we are dealing with a brand new indictment against Donald Trump in relation to January 6th, the election stuff. So the idea, generally speaking, is that between Election Day and the day that Joe Biden was sworn in, that Trump participated in activities designed to steal the election in a way that implies criminality. I am skeptical of this in the first instance, but I'm willing to hear what the U.S. government has to say, as we all should, of course. Try to see what they have to say about the thing, but I'm a little bit skeptical in the first instance about this because especially a lot of this has to deal with time as well, about what was true at various points in time. And given the limited coverage I've seen already on this, which I haven't seen much, but I've seen a little bit as I was watching Sean cover this, for example, and participating a little bit, there seems to be a lack of clarity in the timeline, which I think might be somewhat deliberate. There's a different knowledge base that's available, say the day after the election versus the day before Joe Biden is sworn in. Those are two different situations on what someone knows or what they could know, because there is more certainty about various things. So the degree to which they're conflating dates or conflating the timeline gets to me a little bit. So we're going to see about how that. So we'll see how this all goes, but this is the indictment as it's come down, and we'll see what the case of the U.S. government is. So we want to charge him with conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights, which that 241 in particular is an interesting one, that, with color of law, try to deprive someone of rights in a criminal way. You don't see that come up very often, but let's see what we got. Okay. The defendant, Donald Trump, was the 45th president of the United States and a candidate for re-election in 2020. The defendant lost the 2020 presidential election. Despite having lost, the defendant was determined to remain in power. So for more than 2 months following Election Day on November the 3rd, which would take you to December and then January, the defendant spread lies that there had been an outcome-determinative fraud in the election that he had actually won. Outcome as relating to what, I suppose? Outcome as relating to a particular precinct, outcomes that relates to a particular district, outcomes as it relates to a state, outcome as it relates to the election as a whole. Outcome determined fraud with respect to what? What outcome? The claims were false, and the defendant knew they were false. Did he? At all points did he know they were false? Did he? But defendant repeatedly and widely disseminated them anyway, to make his knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration and the election. I'm not particularly sure the U.S. government is particularly helping when it comes to public confidence right now. When the leader of one party is going after the leader of another party, doesn't particularly help. The government says the defendant has a right, like every American, to speak publicly about the election and even claim falsely that there had been outcome-determined fraud during the election that he had won, which is correct. The First Amendment generally does protect the right to speak falsely. Now, when you're talking about a particular individual, of course, you can get into issues of defamation. But there's one of the lesser-known aspects of New York Times versus Sullivan is it's actually legally impossible to defame the government. So that's interesting. You cannot defame the government. Maybe individuals in the government, but not the government. And there is right generally to spread falsehoods. You can speak falsely. Falsehoods are protected by the First Amendment. They're only not protected when they're being used to further some other illegitimate end. Like, for example, fraud. I'm lying to you to induce you to give me money. That kind of thing. But merely spreading lies is legal. Much of mainstream news media would like to, make sure that that's true for no other reason. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. So he can challenge the results. He can spread lies. He can seek recounts, he can seek audits, he can seek lawsuits. All that's lawful, which, one would imagine. And in many cases, defendant did pursue these methods. His effort to change the outcome in any state through recounts, audits, or legal challenges was uniformly unsuccessful, which doesn't speak to its illegality, by the way, of course. Just because something doesn't work doesn't mean it isn't legal. All right, shortly after Election Day, defendant also pursued unlawful means of discounting legitimate votes and subverting election votes. In doing so, defendant perpetrated 3 criminal conspiracies. A conspiracy to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government. A conspiracy to corruptly obstruct and impede January 6th congressional proceedings at which the collected results of the presidential election are counted and certified. A conspiracy against the rights to vote and have one's votes counted. Okay. Each of these conspiracies, which built on the widespread mistrust defendant was creating through pervasive and disabling lies about election frauds, target a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election. Okay. That's an interesting preamble. So he can do legal things. He can do illegal things. Okay. All right. Then they say from on or about November the 14th, 2020 through on or about January 20th in the District of Columbia, during a time, incidentally, that Donald Trump is president, which raises potential issues because, he has the mantle of it. He's not just anybody, right? He's using federal government power, and he's the head of the executive branch. So his role here is interesting in terms of being able to be charged with crimes in the scope of his office. Okay. That's a whole legal complication. Donald Trump did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown, to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat lawful federal government function by which the results of the presidential election are collected, counted, and certified. Okay. The purpose of the conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function. Okay. All right. The defendant enlisted co-conspirators to assist him with criminal efforts to overturn the legitimate results. Among these were co-conspirator 1, an attorney who was willing to spread knowingly false claims and pursue strategies defendant's 2020 re-election campaign attorneys would not. But you said earlier that Donald Trump has the right to spread knowingly false claims. Remember? You said that. So his attorney could do it, presumably, especially if they're not in court, right? Co-conspirator 2, an attorney who devised and attempted to implement a strategy to leverage the vice presidential ceremonial role, overseeing the certification proceedings to obstruct. What do you mean by attempted to implement? Exactly. And although it was a very strange legal theory, okay. Co-conspirator 3, an attorney whose unfounded claims of election fraud, which incidentally, remember you said earlier that you could have false claims, they were protected. Defendant privately acknowledged to others sounded crazy, which is also legal. Nonetheless, defendant embraced and publicly anaphylized the disinformation. But you said earlier that he has the right to speak falsely. Do you remember what you said a couple paragraphs ago? That the First Amendment protects falsity? So, okay. Co-conspirator 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham criminal investigations and influence state legislatures with knowingly false claims. But you have the right to speak falsely. You don't have the right to speak falsely to the government? I mean, to legislature? Okay. Hmm. Co-conspirator 5, an attorney who assisted in devising and attempted to implement a plan to submit fraudulent slates of presidential elections to obstruct certification. Co-conspirator 6, a political consultant who implemented him. Castro says they said Trump had the right, not necessarily the lawyers working on him on his behalf. That doesn't really make sense to me, Castro. Why would Trump have the right to do something but not the lawyers working for him who are acting presumably as his agent? So why would that be different? I don't understand. Co-conspirator 6, a political consultant who helped to implement a plan to submit fraudulent slates of electors. That'd be a little bit like saying that you can do something legally, but I as your attorney can't also do that legal thing, which seems odd. Okay. The federal government function by which the results of the election for president of the United States are collected, counted, and certified. Yeah, and black, yeah, the lawyers conspiring to do something legal. Right. Yeah. The federal government's function by which the results of the election for president of the United States are collected, counted, and certified was established through the Constitution and the Electoral Count Act, a federal law enacted in 1887. The Constitution provides that individuals called electors select the president, and each state determine for itself how to appoint the electors, which goes a long way to being able to lobby the states, incidentally. Kestrel says, I thought an attorney work on someone's behalf could not make the claims they knew were false to the court. That's true, but that wasn't what was alleged. At least that's not the way I read it. You're right. You can't make knowingly false representations to the court, but that isn't what they said. I don't remember the word court appearing once in any of that. We could read it again. Where did it say the word court? An attorney who is willing to spread knowingly false claims and pursue strategies. An attorney who devised and attempt to implement strategy to leverage the vice presidential ceremonial role. An attorney who unfoundedly claimed claims of election fraud the defendant privately acknowledged to others sounded crazy. A Justice Department official who worked on civil matters and who with attempt to use the Justice Department to open sham criminal investigations. An attorney who assisted in attempting to implement a plan to submit fraudulent slates of presidential elections. A political consultant. Where did it once say court? So what's your point? I don't understand. The Constitution provided that individuals called electors select the president, and each state determined for itself how to appoint the electors. Through state laws, each of 50 states and the District of Columbia choose to select their electors based on popular vote in the state. After Election Day, the ECA requires each state to formally determine or ascertain the electors who would represent state voters by casting electoral votes on behalf of the content who had won the popular vote, and require the executive of each state to certify the federal government the identity of those electors. Some of those claims were made in court and legal filings. It's implicit in the charge. No. You think it's implicit? That's not even a little bit. I can't even begin to tell you how wrong that is. It's implicit. So the word court is there secretly. If we just put enough lemon juice on it, and we just put enough lemon juice and hold it up to the light, the word court is secretly there. It's implicit. We're doing indictment. So we're doing indictment by implicit now. It's implicit. It's implicitly court. What are you talking about? You do realize that attorneys do things all the time that do not necessarily involve courts, right? For most of my career as an attorney, I haven't done things involving courts because a lot of attorneys don't do things involving courts. What are you talking about? Implicit. Implicit, by the way, implicit would mean that it has to be true. It doesn't have to be true. It's not implicit. Keep reading. Well, I'm responding to the things I'm reading in real time, Isabel. I'm responding to things I've read. It's not there yet. Maybe if it comes up, I'll respond to it then, but it's not there yet. So is my comment on point yet or not? You want me to magically respond to things I haven't read yet? This is going to be a long day, I can tell. This is going to be a long day. Through state laws, each of 50 states and the District of Columbia chose to select their electors based on popular vote in the state. After Election Day, the ECA requires each state to formally define or ascertain the electors who'd represent the state voters by casting electoral votes on behalf of the candidate. Also, by the way, this is just a good example of reminding to yourself what I said earlier. Remember what I said earlier about time and timelines? Remember, and what you know and what you don't know at certain times. So will they mention courts later in the document? I don't know, but they haven't mentioned it yet. So how can I factor it into consideration now? Because I haven't read it yet, because I don't have that information, because they haven't said it yet. So my commentary of my reading the document is based on the things that I've already read, because I don't know those things yet, because that's how time works. Timelines. Timelines, my friend. After Election Day, the ECA required each state to formally determine or ascertain the electors who would represent the state's votes by casting electoral votes on behalf of candidates who had won the popular vote, and required the executive of each state to certify to the federal government the identity of those electors. The literal brain, such a beautiful and annoying thing to possess. Then the day on the date set by the Electoral Count Act, each state's ascertained electors were required to meet and collect the results of presidential elections. That is, to cast electoral votes based on the state's popular vote and to send their electoral votes along with the state's executive certification that they were the state's electors to the United States Congress to be counted and certified. Finally, the Constitution and ECA required that on the 6th day of January following each election day, Congress meet in a joint session for certification, preside over the Vice President as President of the Senate to count the electoral votes, resolve any objections, and announce the result, thus certifying the winner of the presidential election as President-elect. I'm going to have to just turn off the chat completely for myself because I can't deal with it. So I'll just turn it off privately for myself so I can't see chat. The federal government, from this point of ascertation to the certification, is foundational to the United States determination process. Until 2021, had operated in a peaceful and orderly manner for more than 130 years. Well, I don't know about that. I mean, there were other incidents throughout history, but we won't let the finer points of history get too much on it. Okay. All right. So manner and means of the conspiracy. All right. How are we going? Be nice, Sandra says. Can I just do my job, please? Would that be okay? Can I do my job? The defendant conspiracy to impair, obstruct, and defeat federal government function through dishonesty, fraud, and deceit to include the following manner and means. Defendant and co-conspirators usually knowingly falsely claim of election fraud to get state electors and election revolts officials to subvert the election and to change electoral votes for a defendant's opponent to electoral votes for the defendant. knowingly false claims of frauds to subvert legitimate results. On the pretext of baseless false fraud claims, defendant pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. Okay, I'm just going to have to just close Discord for myself too. That's fine. I don't need that either. The defendants and co-conspirators organized fraudulent slates of electors in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, Wisconsin, attempting to mimic the procedures that legitimate electors were supposed to follow under the Constitution and other federal and state laws. He did. This included causing the fraudulent electors to meet on the day appointed by federal law on which legitimate electors were to gather and cast their votes, cast fraudulent votes for the defendant, and sign certifications falsely representing that they were legitimate electors. Some fraudulent electors were tricked into participating based on the understanding their votes would be used only if defendants succeeded in outcome-determinative lawsuits within their state, which defendant never did. But that isn't necessarily a trick then. That's just being done in reserve, which is similar to that situation in Hawaii, at least a little bit, from like the 1970s. Defendant and co-conspirators then caused the fraudulent electors to transmit their false certifications to the vice president and other government officials to be counted at the certification proceeding on January 6. Defendant and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and send a letter to targeted states that falsely claimed investigations and send a letter to target states that falsely claimed the Justice Department had identified significant concerns that may have impacted the election outcome that sought to advance the defendant's fraudulent election plan by using judicial department authority to falsely present fraudulent electors as a valid alternative to legitimate electors, and that urged on behalf of the Department of Justice the target state legislature to convene to create opportunity to choose the fraudulent electors over legitimate electors. How many words do we need, man? It feels like unnecessarily verbose. Are we getting paid by the word? It feels a little bit like we're getting paid by the word or something. I don't know. And it also is a little hard to keep track of what they're saying because they're using such verbose language. I'm getting lost a little bit in it because of how it's a little bit, it's like overly flowery. So I'm getting a little bit lost in the language. I'm having a little bit of difficulty parsing exactly what they're talking about because of just how they're writing it. Defendant and co-conspirators attempted to enlist the vice president to use his ceremonial role at January 6th certification proceeding to fraudulently alter election results. First, using knowingly false claims of election frauds, defendant and co-conspirators attempted to convince the vice president to use defendant's fraudulent electors, which arguably could be viewed as petitioning for redress of grievance to a governmental official. So, yeah. Reject legitimate votes or send legitimate electoral votes to state legislatures for review rather than counting them. When that failed, on the morning of January 6th, the defendant and co-conspirators repeatedly knowingly false claims of election fraud to gather supporters, falsely told them that the vice president had authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceedings and exert pressure on the vice president to take fraudulent actions he had previously refused. That seems kind of thin. After it became public on the afternoon of January 6th that the vice president would not fraudulently alter the results, a large and angry crowd, including many individuals who the defendant had deceived into believing the vice president could and might change the results, violently attacked the government and halted proceedings. As violence ensued, defendant and co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. This doesn't feel, I don't know, it feels a little try hard. It feels a little off point. And also, did they? It's conclusory. It's conclusory. It's overly worded. It's overly verbose. It's overly wrought language. It's kind of annoying. I don't get it. I don't understand what's happening. All right, let's see if it gets any better. This is all like prelude still, or it feels like prelude too. It feels like overly verbose prose as a what would you say, like a prelude or an interlude or something. It feels like narrative exposition in a play or something. It feels like a lot of info dump, by a character rather than it feels like telling rather than showing. Maybe that's the problem. Feels like telling rather than showing. Maybe they'll get to that. Defendant, his co-conspirators, and their agents made knowingly false claims that there had been outcome determinative fraud in the 2020 election. What do we mean by outcome determinative? By the way, exactly. Outcome as with respect to what? The ultimate election results, or like a state's results, a county's results, a district's results, a voting precinct's result? What do we mean by outcome determinative? What is outcome with respect to what? With respect to the count? If the count is wrong, is that outcome determinative? It depends what you're viewing it as. Like, if the count is wrong and you fix the count, is that outcome determinative? I suppose it depends what you're measuring against. These prolific lies about election fraud includes dozens of specific claims that there had been substantial fraud in certain states, such that large numbers of dead, non-resident, non-citizens, or otherwise eligible voters had cast ballots, or voting machines had changed votes from defendant to votes for Biden. When? At what time? When were these claims made? What were the claims? When were the claims made? There is a difference between a claim that's made the day after the election versus the day before inauguration. There is more knowledge available between these two dates. When? Right? It's a collapsing of the timeline. The claims are false and defendant knew them to be false. When did they know them to be false? In fact, defendant was notified repeatedly the claims were untrue, often by people whom he relied on in candid advice for important matters and were best positioned to know the facts, and deliberately disregard their truth. For example, the defendant vice president, who personally stood to gain by remaining in office, whom defendant asked to study fraud investigations, told defendant he'd seen no evidence of fraud. When? The senior leaders of the Justice Department appointed by defendant and responsible for investigating critical allegations of election crimes told defendant on multiple occasions that varied allegations of fraud were unsupported. Multiple occasions? What were they? When did they occur? Do you know? Do you know when? The Director of National Intelligence, defendant's principal advisor on intelligence relating to national security, disabused the defendant on the notion the intelligence community's findings regarding foreign interference would change the outcome of the election. When? What did he say? What do you mean that he did? You're telling me, you're not showing me. What did he say? When did he say it? What was the nature of the statement? The Department of Homeland Security, Cybersecurity, and Infrastructure Security agencies, who exist as defendant, signed into law to protect the nation's cybersecurity infrastructure from attack, joined an official multi-agency statement. There is no evidence any voting system had been compromised, and declared the 2020 election the most secure in American history. Okay. All right. Sure. Days later, after the CISA director, who the defendant had appointed, announced publicly the election security experts were in agreement that claims of computer-based election fraud were unsubstantiated, defendant fired him. Is that illegal? Is that part of the pattern of conduct? The president fires someone? It implies it's illegal, or it implies it's part of the conspiracy. Is the president firing people part of an illegal conspiracy now? Okay. Senior White House attorneys. Which ones? How senior? What do we mean by senior? Who are they? Selected by defendant provide him candid advice. How did he select them? Do you mean he appointed them? Do you mean like he knew them personally? Who are these people? Informed defendant there was no evidence of outcome determined election fraud and told him the presidency would end on Inauguration Day of 2021. Senior staffers on the defendant's 2020 re-election campaign, whose sole mission was the defendant's re-election, told defendant on November 7th, hey, we finally have a date. That they had only a 5 to 10% chance of prevailing in the election, and success was contingent on defendant winning overall vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that, defendant lost Arizona, meaning he had lost the election. Well, that it was clear within a week. So you think that by November 14th of 2020, it was clear beyond any sort of doubt that Donald Trump had lost Arizona? That's a very aggressive timeline that, that you think that would be known for certain. By the way, just for a kindly reminder of you guys, for the 285 of you who are currently here, just want to say thank you for being here. And just want to say, hit the like button if you don't mind. And so far, this is conclusory. It is, I hope it gets better, but it feels very wrought. And yeah. State legislatures and officials, many of whom were defendant's political allies, had voted for him and wanted him to be reelected, repeatedly informed defendant that claims of the fraud in their states were unsubstantiated. Which states, which officials, when, at what times? See, when you're talking about, again, at the risk of belaboring the point, when you're talking about someone doing something knowingly, which by the way, for it to be a lie, it has to be knowingly false. That's what makes something a lie, that you know that it's false. If you just tell a falsehood, it's merely false because maybe you don't know what you're saying is wrong, because people make mistakes and people aren't all knowing. So it's only a lie if you know, right? It's only a lie if you know. And so when they're talking about Donald Trump like knowingly committing fraud, knowingly spreading falsehoods, when he knew becomes kind of important relative to the conduct. Because if the conduct occurred before he knew, well, then that's kind of a logical problem. So I'm not just saying it just to be like belligerent. I'm saying it because it legally matters. Rogue Accountant gives $20 to say thank you for having us here and the work you put in. You're welcome. I appreciate that, Rogue Accountant. Thank you very much for your super chat, which I can see, notwithstanding the fact I closed chat, because it shows up on the image. So if you want to talk to me, I guess super chats are still a way to do that. So you got that going for you. All right, let's see what else we got. The defendant widely disseminated his false claims of election fraud for months, despite the fact they knew, in many cases been informally directed that they were not true, which again, merely spreading falsehoods is legal, as you mentioned earlier. Defendant's knowingly false statements were integral to his criminal plans to defeat federal government function, obstruct certification, and interfere with others' right to vote and have their votes counted. Had he made these knowingly false claims throughout the post-election time period, including those below that he made immediately before the attack on January 6th. What do you mean by immediately before? Normally, when I think immediately before, I'm thinking to myself, 5 minutes. Because that would be kind of like immediate. What do you mean by immediately before? Defendant insinuated that he had more than 10,000 dead voters in Georgia. Just 4 days earlier, Georgia Secretary of State explained to defendant they were false. But he's allowed to make knowingly false statements, generally speaking. Because who's he talking to? What do you mean he insinuated? The defendant asserted there had been more than 205,000 more votes. Where's some quote marks? What did he say? What do you mean he insinuated? What do you mean he asserted? Where's some quote? What did he say? To whom? When? Where? Under what context? This is kind of important because, you need to know who he's talking to. If he's talking to the press, $5 from Bush McFadden, brilliant constitutional mind, Kurt. Thank you. And I many appreciate my first super chat to you. Well, thank you, Bush. I know you've been a longtime supporter of the channel, and I appreciate the super chat. Thank you. That's very, very kind of you. I appreciate your support. So where are some quote marks, though? My kingdom from some quote marks right about now is what I think. Defendant said there had been suspicious vote dump in Detroit, Michigan. Yeah, I remember this because it was a weird artifact of how Detroit reported their votes. I remember this. So the defendant's attorney general had explained to the defendant they were false. And defense allies in Michigan state legislature, the Speaker of the House of Representatives and Majority Leader had publicly announced there are no evidence of substantial fraud. Yeah, I kind of remember this because I looked into it at the time. It's been a while, so you'll have to forgive me. But it was an artifact of how Detroit and the county it was in reported absentee ballots, or they reported early voting ballots. I forget exactly what it was, but like for every other part of the state, they reported the numbers for like absentee ballots or early voting ballots or something like that as part of the voting totals for the vote as a whole. But for some reason in Detroit and the county in which Detroit was in, they separated them out. So when you looked at the numbers that they were reporting, it would say something like, and again, it's been a while, but it would say something like, early vote total 0 or absentee vote 0, which, didn't really make sense because for some reason they separated it out in Detroit and they reported it on a different page, a couple pages down. Even though they didn't do that for other places in the state. I don't remember why they did it that way, but they did. And you did have to look at the number two different ways. So if you just looked at the number like the way it was reported and you compared it to the way other numbers were reported in the state, it would look wrong. And it wasn't until you understood that for some reason they separated it out that you understood what was going on. So, that it was confusing, I understand, because it was confusing. I'm not sure why they did it that way. Defendant claimed there have been tens of thousands of double votes and other frauds in Nevada. Nevada Secretary of State had previously rebutted defendant's fraud claims by publicly posting a facts versus myth document explaining Nevada judges had reviewed and rejected them. The Nevada Supreme Court had rendered a decision denying such claims. Well, I mean, also not to put too fine a point on it, but you could also disagree with a court, which I've done from time to time. So if a court says something and then I'm like, well, that's not true, does that mean that I'm engaged in fraud because I disagree with the court's assessment of something? I disagree with their assessment of some aspect of something, and I'm like, no, I don't agree with that. Is every appeal by an attorney now implicitly fraud? Is every appeal by an attorney implicitly fraud because hey, don't you know, attorney, that the court ruled against you and you're perpetuating a falsehood that the court is wrong? So is every appeal illegal now? This is a new and exciting reality. Defendants asserts the voting machines of various contested states had switched voters from defendant to Biden. When did he make the assertion? Because again, timeline, people, timeline. Also, what did he say? How did he assert it? Where are my quote marks? Where are my quote marks? My kingdom for some quote marks. And the defense attorney general, the acting attorney general, and the acting deputy attorney general all explained to him this was false. And numerous recounts and audits had confirmed the accuracy of the voting machines. Okay. All right. So the criminal agreement and acts to affect the objects of the conspiracy. Defendants' use of deceit to get state officials to subvert legitimate election results and change the electoral votes. Okay. Shortly after Election Day, which fell on November the 3rd, defendant launched his criminal scheme. On November the 13th, defendant's campaign attorneys conceded in court that he had lost vote counts in the state of Arizona, meaning on the basis of that assessment of the defendant's campaign advisors had given just a week earlier, defendant had lost the election. What did they say exactly? What was the nature of the concession? I don't remember exactly. You know. So the next day, defendant turned to co-conspirator 1, whom he announced would spearhead his efforts going forward to challenge the results. So maybe he would like to challenge the court decision? From that point on, the defendant and its co-conspirators executed a strategy of using knowing deceit in targeted states to impair, obstruct, and defeat the federal government function, including described below. In Arizona. Okay. So this is a federal government function from Arizona. Okay. On November 13th of 2020, defendant had a conversation with his campaign manager, who informed him that a claim had been circulating. A substantial number of non-citizens who voted in Arizona was false. On November 22nd, 8 days before Arizona's governor certified the ascertainment of the state's legitimate electors based on popular vote, defendant and co-conspirator 1 called the Speaker of the House of Representatives of Arizona and made knowingly false claims of election fraud aimed at interfering with the assessment of voting elections. In November 22nd. Okay. So you think that he made you think it was knowingly false on November 22nd? Okay. Defendant and co-conspirator 1 falsely asserted, you presumably mean knowingly falsely asserted, among other things, that substantial numbers of non-citizens, non-residents, and dead people had voted fraudulently in Arizona. The Arizona House Speaker asked co-conspirator 1 for evidence, which co-conspirator 1 did not have, but claimed he would provide, but never did so. So, is that fraud? Right? Because the other person's like, can you provide that to me? Is that really fraud? And it only is fraud if you know it, by the way, and that's not clear. Defendant and co-conspirator 1 asked the Arizona House Speaker to call the legislature into session to hold a hearing based on the claims. That's not illegal. To ask the Arizona House Speaker to call legislature into session for a hearing, that's not illegal. The Arizona Speaker refused, saying doing so would require 2/3 vote of its members. It would not allow it without actual voter evidence of fraud. But it's not illegal to ask for it. And it's like, I'm not going to do it, but it's not illegal to ask. You know, if I call my Congress critter and be like, can you hold a special meeting of Congress because I'm really upset about something, that's not illegal, is it? I don't think so. Defendant and co-conspirator 1 asked the House Speaker of Arizona to use the legislatures to circumvent the process by which legitimate electors would be ascertained based on the popular vote and replace those with a new slate by defendant. The Arizona House Speaker refused, stating the suggestion was beyond anything he'd ever heard or thought of something as something within his authority. This is not This at the time is certainly not an illegitimate idea, right? As you pointed out earlier in your own document, US government and Jack Smith, as you pointed out earlier, it's up to the legislature. It's up to the state of each, it's up to each state to determine how their electors are to be determined. And the popular vote is certainly a method, but not necessarily the only method. Now, incidentally, they've recently changed the Electoral Count Act to prevent legislatures from going back and changing the method after the date of the election. But this wasn't invalid at the time. I don't think it was invalid at the time. I think that if a state wanted to overrule the will of the voters by having the legislature meet and put forward a different slate of electors, they could have, because the Constitution says they can. The Constitution says each state gets to decide how to choose the electors, which could be by popular vote, but it doesn't have to be. So if they're like, we don't like those results, let's cast different slates, that would be legal. It would come with enormous political consequences because the voters would be pretty pissed, but it would be legal. So the Arizona House Speaker saying it was beyond anything that he would consider, like, okay, but it's not illegal in the first instance. Okay. On December 1st, the co-conspirator met with the Arizona House Speaker. When the Arizona House Speaker again asked co-conspirator for evidence of outcome determinative election fraud that he and the defendant had been claiming, and again, what do we mean by election outcome determinative, by the way? Because now we're talking specifically about Arizona. So do we mean as it relates to Arizona? Do we mean as it relates to a county in Arizona? Do we mean as it relates to, what do we mean exactly here? Co-conspirator one responded with the words, the effect of, we don't have the evidence, we have lots of theories. Now, I took a note of this in Sean's stream, and I particularly object to this. I make special objection to this. Words to the effect of, and then it follows it with a quote mark. That is just wrong. Words to the effect of, and then a quote mark. So the one time you break out a quote mark is when you yourself acknowledge it's a paraphrase. I am not a happy camper. I'm not a happy camper. My kingdom for a quote mark, and the first time you break out a quote mark, it's words to the effect of. Not these words that are like these words, but we're going to put them in quote marks anyway. Do you understand how quote marks work? Do you understand how quote marks work? I am very unhappy camper. On December the 4th, the Arizona House Speaker issued a public statement that said, in part, oh, look, gift memberships coming in. Oh, that's nice. Who we got it from? Jennifer gifts 20 gift memberships to the viewers. Well, thank you, Jennifer, for the gift memberships. That's very, very thoughtful of you to gift so many gift memberships to everyone. And just a kind reminder that you too can get a membership by hitting that beautiful, beautiful join button and helping to support Uncivil. And now we get all the names of all the people who have become members on screen. Very exciting. Congratulations to all our new Uncivilians. You are welcome and loved. On December the 4th, the Arizona House Speaker issued a public statement that said, in part, no election is perfect. And if there are evidence of illegal votes or improper count, then Arizona law provides a process to contest the election, a lawsuit under state law. But the law does not authorize the legislature to reverse the results of an election. Actually, I think it does, because the Constitution says so. Now, again, they just changed this in the Electoral Count Act. They just revised this, but at the time, I think it does. As a conservative Republican, I don't like the results of the presidential election. I voted for Trump and I worked hard to re-elect him, but I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. I and my fellow legislators swore an oath to support the U.S. Constitution and the Constitution laws of the state of Arizona. It would violate that law oath, the basic principles of Republican government, and rule of law if we attempt to nullify the people's vote based on unsupported theories of fraud. Under the laws that we wrote and voted upon, Arizona voters choose who wins, and our system requires their choice be represented. Well, fair enough. I mean, you don't want to undo that because, well, even if it were legal, which it almost certainly was, but it would be massively politically unpopular. So fair enough. On the morning of January 4th of 2021, co-conspirator 2 calls the Arizona House Speaker to urge him to use a majority of legislatures to decertify the state's legitimate electors. Yeah, that would be legal. Arizona validly asserted electors had voted 3 weeks earlier and sent their votes to Congress, which was scheduled to count those votes in Biden's favor just in 2 days' time. When the election House Speaker explained the state investigation uncovered no evidence of substantial fraud in the state, co-conspirator 2 conceded the state that he didn't know enough about the facts on the ground in Arizona, but nonetheless told the House Speaker to decertify and let the courts sort it out. The Arizona House Speaker refused, saying he would not play with the oath he had taken. Yeah, I mean, but this is legal at the time, right? Like, at least at the time, the state legislatures could do this, at least in my view. The law seemed to allow for it. Now, you are at this point, because of when this is, coming into conflict with some federal law about, because you're past the presumptive validity date. So you're going to have some real problems getting those votes validly recognized. But there's nothing wrong with Arizona trying, right? And then the federal government can be like, no, we're not going to recognize them because they are past the date for, the certification. So it's too late to put them into the hopper. But this isn't illegal for Arizona to try, not at the time. On January 6th, defendant publicly repeated the knowingly false claim that 36,000 non-citizens have voted in Arizona. As to Georgia, okay, so as to Arizona, I'm not particularly impressed. Maybe it gets better with respect to Georgia. On November 16th of 2020, and on defendant's behalf, his executive assistant sent co-conspirator 3 and others a document containing bullet points of certain voting machine company writing, see attached, please include as is or almost as is in lawsuit. Co-conspirator 3 responded 9 minutes later, writing, it must go in all lawsuits in Georgia and PA immediately with a fraud claim that requires the entire election to be set aside in those states and the machines impounded for nonpartisan professional inspection. On November the 25th, and see, November the 16th, right, is pretty early in this process, right? We're not even 3 full weeks out, or 2 weeks at this point, because the election's on the 3rd, right? So this is 13 days. So we're not even quite 2 weeks out from the date of the election. So at this point in the process, there wasn't as much known about the voting machines as there would be later. And also, by the way, for what it's worth, and Nate Brody has pointed this out as well, the Democrats in the run-up to the election have been making all kinds of arguments about the uncertainty of voting machines and the unreliable voting machines and how they could be tricked and stolen from and all the rest of it. So, in this period of time, this was not exactly a completely, this was not necessarily as a absurd point as it might later become. On November the 25th, co-conspirator 3 filed a lawsuit against the governor of Georgia, falsely alleging massive election fraud accomplished through voting machine companies' election software and hardware. Before the lawsuit was even filed, the defendant retweeted a post promoting it. Oh, okay. You mentioned earlier, remember that the defendant has the right to go to court and file things. And on November 25th, did they know that this was wrong? On November 25th? I mean, I'm not sure they did. Of course, information would come out later, right, with respect to voting machines. But again, everything's about time. And what did people know at various times? So to Kestrel's point earlier, now that we're finally talking about courts, right? So you have to ask, so can you lie to a court? No. Okay. On November 25th, when you filed a lawsuit falsely alleging massive election fraud, on November 25th, did they know that was false? Did they have a good faith basis for potentially believing it's true? Were they lying to the court, or were they merely engaged in good advocacy? On November 25th. When this occurs is important. What did they know? What did they believe to be true? What was their basis of believing it true? What was their good faith basis? The fact that it might ultimately prove to not have basis. Doesn't speak to what they knew on November 25th. The timeline is important when we're trying to assess guilt. So, yeah. So that's what I would say about that. On December the 3rd, December the 3rd, apologize. On December the 3rd, co-conspirator 1 orchestrated a presentation to Judiciary Subcommittee of the Georgia State Senate with intention of misleading state senators into blocking assertion of legitimate electors. During the presentation, agent of the defendant and co-conspirator 1 falsely claimed that if he's an agent, is he not also a co-conspirator? I digress. Falsely claimed that more than 10,000 dead people voted in Georgia. That afternoon, a senior advisor to defendants told defendants chief of staff through text messages, just FYI, a campaign lawyer and his team verified that the 10,000 supposedly dead people voting in Georgia is not accurate. It was alleged in the hearing today. Okay, so at the time he said it, did he know it was false? Later in the day, he got a text message telling him it was false. Did he know it at the time he said it? Time matters. If I go to Congress and I say something, and later that day I get a text message telling me that was wrong, well, I might know now, but did I know then? Time matters. Another agent of defense, and also, incidentally, just because I'm being told it doesn't necessarily mean that I believe it. I can be told all kinds of things by all kinds of people. So just because someone tells me doesn't mean that I know it to be false, right? If you tell me the sky outside is green, and I'm like, I say the sky is blue, the fact that you told me doesn't change my belief in my own knowledge, because I don't find you to be reliable and credible. So, when you think about knowing, there's also an issue of who is this person? So a campaign lawyer and his team, who are they to me? What is their reliability? What other investigations are going on? And so forth and so on. So it muddies the water. Another agent, defendant, and co-conspirator 1 played a misleading excerpt of video recording of ballot counting at State Farm Arena in Atlanta and insinuated it showed election workers counting suitcases of illegal ballots. At the time, was that really what they knew? Because I know exactly what they're talking about, right? With these ballots that were put under the table for counting later. But in the video recording, it looked a little suspicious. Now, later it came out with an explanation that, at least to me, I found satisfying. You may or may not have found it satisfying, but I found it satisfying, right? We put the election ballots under this place to be later counted. We got them out of the place to be counted, and everything is fine. But did they know that it was a misleading excerpt at the time they showed it? Was that information known to them at that time? Or did they not know what it showed or what? Like, what the whole thing about what their information base is unclear here. Co-conspirator 2 encouraged the legislature to defer certified state elections based on false allegations of fraud, which you have a right to speak falsely. You have a right to petition your government for redress of grievance. So you're saying that you can't tell falsely in your right to petition? So you have a right of freedom of speech to speak falsely, but not a right of petition to speak falsely? Is that what we're doing? That doesn't seem quite right. Also on December 3rd, defendant issued a tweet amplifying the knowingly false claims. He knew them to be false by saying, wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Yeah, that too. That was part of that whole thing where they're like, oh, we're going to close up shop for the day. Remember that? We're going to close up shop for the day. All the Republicans left the place because they're like, oh, we're done counting for the day. Come back tomorrow. And then later, the Democrats got the call being like, we want you to continue voting or continue counting. And the Republicans were not in the room. I remember that. That was kind of suspicious. That was kind of suspicious, right? That all the Republicans were excluded, and then suddenly we're counting ballots without the Republican voting representatives being present, as they're required to be by law, which seemed a little suspicious. So, was it ballot stuffing? Probably not. But the Republicans, you can either believe it was all one massive misunderstanding, or you can believe something more nefarious, but it definitely wasn't a good look. It definitely wasn't a good look. Plenty more coming, but this alone leads to an easy win in the state. Well, not so much, but did he know that at the time? On December 4th, the Georgia Secretary of State's chief operating officer debunked the claims made of co-conspirator. Thank you, Leaf Lover Liz, for becoming a member. Thank you for hitting that beautiful, beautiful join button. That's appreciated. Issuing a tweet stating the 90-second video of the election workers at State Farm Arena purporting to show fraud was watched in its entirety by Georgia State Secretary of State investigators, shows normal ballot processing. Here's the fact check on it. On December 7th, he reiterated during a press conference the claim that there had been misconduct was false, which, well, it wasn't exactly done in the way it's supposed to be done according to the rules. So there was that. On December 8th, the defendant called Georgia Attorney General to pressure him to support an election lawsuit filed in the Supreme Court by another state's Attorney General. The Georgia Attorney General told the defendant that officials had investigated various claims and were not seeing evidence to support them. Pressure him to file a lawsuit? But it had been filed by another state's Attorney General. So I'd like you to join this lawsuit? That's pressure? Or is that advocacy? Right? Is that I'd like you to join on to this? Is that advocacy or is that illegal conduct? This state joined in. Will you like to sign on too? This feels overwrought. Hey, some more gift memberships. That's nice. Who is it today? Steve A gifts 20 gift memberships to viewers. Thank you, Steve A, for gifting 20 gift memberships. That's very, very thoughtful. Thank you. And to the 20 new uncivilians who get to join the fold, thank you. Your continuing support of this channel is appreciated. Also on December 8th, a senior campaign advisor who spoke with defendant on a daily basis and informed him on multiple occasions of dates that we're not going to mention, by the way, that various fraud claims, which fraud claims were untrue, expressed frustration that many of co-conspirator 1 and legal team's claims could not be substantiated. Well, by December 8th, maybe. See, December 8th is later in time than like November or October or September. So by December that they can't be substantiated, well, yeah. I mean, we went through the process and things didn't pan out as one does. It's imputing knowledge backwards, because the way it reads to me, and maybe it's just me, but the way it reads to me is like, because on December 8th, he said this, that Donald Trump knew of it sooner. Right? And it's like, oh, this is just an admission of what Donald Trump knew all along. Of course he knew it, said it on December 8th, because by then the truth was so obvious that not even he could deny it. Brr. Right? It feels like we're trying to go backwards in time. It feels like we're trying to use later developments to impute earlier developments. Maybe that's just me. Maybe that's just the way it's writing or coming off the page to me, but it feels a little unfair. They talk about as early as mid-November, for example, the senior campaign advisor had informed defendant that claims of a large number of dead voters were untrue. With respect to the false claims of the state arena, on December 8th, the state campaign advisor wrote, with our research and campaign legal team can't back up any of the claims made by our elite strike force legal team. You can see why we're 0 to 32 on our cases. Obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy shit beamed down from the mothership? Well, at that point, again, like we're later in time, right? The lawsuits which were initially filed in the state of uncertainty and lack of clarity are now not coming to pass. So it feels a little I don't know, just On December the 10th, 4 days before Biden's validly asserted electors were scheduled to cast votes and send them to Congress, co-conspirator 1 appeared at a hearing before the Georgia House of Representatives Government Affairs Committee. Co-conspirator 1 played a State Farm video again and falsely claimed it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then he cited 2 election workers by name, basically accusing them of quite obviously surreptitiously passing around USB ports as if they're vials of heroin or cocaine. Okay, you got to laugh out of me. That's funny. And suggested the criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. I have USB ports. I have many of them on my computer. Do you have any USB ports? Maybe we're looking for USB flash drives. How do you pass around a USB port? That's a neat trick. How do you pass around a USB port? Are you passing around a hub, a USB hub? Hey, look at this new piece of tech, man. It can accept 10 different USB devices. Oh, look how so cool it is, man. This USB hub, man. I'm all about that. Oh, this one's got 12, man. Oh, it's the sexiest port ever. Which USB port, which USB port is sexiest USB port? Is it USB A? Is it USB B? Is it USB C? Are there any hardcore people out there still fighting for USB B other than the printers? Not many USB B people running around. USB B is where it's at. We've all been undersold, man. This is good stuff. On December the 15th, defendants summoned the incoming acting attorney general, including the incoming acting deputy attorney general and others to the Oval Office to discuss allegations of election fraud. The president is meeting with his senior advisors. During the meeting, Justice Department officials specifically refuted defendants' claim about State Farm Arena, explaining to them the activity on the tape was benign. The President of the United States is asking to meet with his advisors. Hold on. What is the exact constitutional text here? I need a copy of the Constitution. Hold on. Where are you? This is always fun when you're trying to find an exact clause in the Constitution. Trying to remember exactly where it is. Oh, okay, I found it. I got it. All right. All right. Article 2, Section 2. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of several states when called to actual service of the United States. He may require the opinion, in writing, of the principal officer of each executive department upon any subject relating to the duties of their respective office. The president wants to talk to his senior advisors and get their opinion. Okay. That's good news. That's super nefarious. On December the 23rd, a day after the defendant's chief of staff personally observed the signature verification process at Cobb County Civic Center and notified defendant, state election officials were conducting themselves in exemplary fashion and would find fraud if it existed. Defendant tweeted that the Georgia officials administering their signature verification process were trying to hide election voting fraud, which again, he's allowed to spread falsehoods. Remember, you mentioned that earlier? You're using his tweets against him. But you mentioned earlier he's allowed to lie, right? Because you're talking about him tweeting. And you mentioned earlier that you're allowed to lie. So, okay. On December 23rd, a day after defense chief of staff personally observed signature verification process at Cobb County Civic Center, notified defendant that state election officials were conducting themselves in exemplary fashion and find fraud. Defendant tweeted that the Georgia election officials administering the signature verification process were trying to hide evidence and were terrible people. In a phone call on December 27th, this defendant spoke with the acting attorney general and acting deputy attorney general. During that call, defendant again pressured unfounded claims regarding state arena. Wait a second. Which? Okay. I think you mean the federal ones, although it's a little unclear here. During the call, defendant again pressed unfounded claims of State Farm Arena, and two top Justice Departments again rebutted the allegations, telling the Justice Department had reviewed videotape and interviewed witnesses and none of them identified any suspicious conduct. On December 31st, defendant again signed a verification affirming false election fraud allegations made on behalf in a lawsuit in his name against the Georgia governor. So he's committing fraud on the court. So his lawsuits, which you said he could file, are okay. I'm confused about, is this illegal conduct? And all right. In advance of the filing, co-conspirator 2, who was advising the defendant on the lawsuit, acknowledged in an email that he and defendant had, since signing a previous verification, had been made aware that some of the allocations and evidence proffered by experts had been inaccurate, and signing a new information with knowledge and incorporation by reference would not be accurate. Defendant signed it nonetheless. Okay, so at this point now you've got him on fraud before the court. Or at least the co-conspirator is, who presumably is a lawyer. So you got them knowingly committing falsehood to a court. So, okay, you got that. Because apparently they know it's wrong. So they're lying to the court. That's bad. I'm not sure it's criminal bad. It's sanctionable bad. It's get your lawsuit dismissed. It's possibly contempt bad. But I'm not sure it's any of these things bad. It's lose your license bad if you're an attorney. Don't commit fraud before the court. So, but okay, you finally have something, I guess. On January 2nd, 4 days before Congress's certification, defendant and others called Georgia's Secretary of State. During the call, defendant lied to Georgia's Secretary of State to induce him to alter Georgia's popular vote count and call into question the validity of Biden's electoral votes, which had been transmitted to Congress weeks before, including as follows. Defendant raised allegations regarding State Farm Arena video and repeatedly disparaging one of the same elector workers the co-conspirator 1 had maligned on December the 10th, using her name almost 20 times and falsely referring to her as a professional vote scammer and hustler. Okay. In response, the Secretary of State of Georgia refuted this, saying, "You're talking about the State Farm video. I think it's extremely unfortunate that co-conspirator 1 or his people, they sliced and diced that video and took it out of context. When the Georgia Secretary of State then offered a link to the video that would disprove the claims, the defendant responded, I don't care about a link. I don't need it. I have a much better link. That sounds like something that Trump would say. Defendant asked about rumors that paper ballots cast in the election were being destroyed, and the Georgia Secretary of State counsel explained to him the claim had been investigated and was not true. The defendant claimed that 5,000 dead people voted in Georgia, causing the Georgia Secretary of State to respond, well, Mr. President, the challenge you have is your data is wrong. The actual number was two. Two people that were dead were voted. And so your information was wrong. That was two. The Secretary of State seems to know what's up. This is fraud? This is the worst fraud ever. This is fraud? This is fraud to deprive the United States and interference? I don't know. I'm not sure I see it. And I want to be fair. I really want to be fair, and I really want to be honest. And I want to be a good legal educator among everything else, right? I want to adjudicate things as fairly as I can, regardless of party and regardless of whatever is going on. And I don't know if I'm being overly critical of this or not. I'm second guessing myself a little bit. Springstorm gives 10 memberships. I don't know if I'm being overly critical of this or properly critical of this, but it just feels a little thin. It feels thin, it feels stretchy, it feels overwrought. It feels like Donald Trump says some shit, but he's not really confusing anyone. He's not really tricking anyone. All these people want to see evidence. He says, I've got so many facts. I've got so many facts. I've got the best facts. Where are they, Mr. President? So many. Okay, those facts aren't very good, Mr. President. I've got so many facts. So I want to be fair to both sides. I want to be a good educator, and I don't. I'm just not persuaded by this, as opposed to like the issue dealing with the classified documents, where they are pretty good. I haven't taken a look at the superseding indictment, by the way, with respect to the destruction of the videotape or whatever that's about. But at least in my initial evaluation of the whole thing, I thought that was pretty good and pretty solid. And I thought that, the one in New York from Bragg was pretty shit. And this one, it feels a little like clutching at fat. It feels a little like we're clutching at fat, clutching at straws, clutching at straws. It feels a little bit like, I don't know. That January 6th, it feels a little bit like we're trying to find any reason to charge him for the riot on January 6th, and we can't do it, so we have to make something up. It feels like you show me the crime and I'll find you you show me the person, I'll find you the crime, right? It feels a lot like, okay, the riot of January 6th happened, and Donald Trump said some shit, and people believed the shit, and those people rioted, and we should be able to hold Donald Trump accountable for that in a legal sense, right? We can't get him for incitement. We can't get him for incitement. We can't get him for conspiracy to, attack the Capitol. We can't get him for any sort of direct involvement with January 6th. So we want to use the fact that he can spread lies, which is true. He can. And that some people believed those lies and then took it upon themselves to attack the Capitol. And now we want to be able to go after the lies. And it looks like we're trying to use anything we can find to try to hold him accountable when we can't really do it. He's not really responsible for the riot, but we really want him to be. It feels like our motives are polluting our judgment on the record. And, it just feels disingenuous. The defendant claimed thousands of out-of-state voters had cast ballots in Georgia elections, with the Georgia Secretary of State's counsel refuting, explaining, "We've gone through each of those as well as those numbers we've got, and defendant's counsel was just saying they're not accurate. Even ones we've been through are people that lived in Georgia, moved to a different state, but then moved back to Georgia legitimately. They moved back 10 years ago. That was not like something just before the election." In response to multiple other defendant's allegations, the Georgia Secretary of State's counsel told defendant that the Georgia Bureau of Investigation was examining all such claims and finding no merit. Defendant said he needed to find 11,780 voters and insinuated, again with insinuation, why not quote marks, that the Georgia Secretary of State and his counsel could be subject to criminal prosecution if they failed to find election fraud as he demanded, saying, "Okay, we're finally going to get quote marks? Thank God. And you're going to find that they are, which is totally illegal. It is. It's more illegal for you than it is for them because you know what they did and you're not reporting it. That's criminal, you know. That's a criminal offense. And you know, you can't let that happen. That's a big risk to you and the Georgia Secretary of State's counsel, your lawyer." That feels like Donald Trump saying some shit, which he is known for. The next day, on January 3rd, defendant falsely claimed the Georgia Secretary of State had not addressed defendant's allegations, publicly stating that Georgia Secretary of State was unwilling or unable to answer questions such as the ballots under the table scam, ballot distraction, out-of-state voters, dead voters, and more. He has no clue. He said that in a tweet. He's allowed to lie, remember? On January 6th, the defendant publicly repeated knowing and false insinuation. He's allowed to lie. He's allowed to lie. He's allowed to make knowingly false statements. The First Amendment protects knowingly false statements. You're allowed to lie. It's only when the false statements are being used for some other criminal purpose it becomes a problem. But the statements unto themselves are legal. All right, how much more of this do I have? On page 17 of 45. Hold me, chat. We're going to be here for a while. Hold me. All right. In Michigan, on November the 5th of 2020, defendant claimed there had been suspicious dump of votes, purportedly illegal ballots, stating in Detroit there were hours of unexplained delay in delivering many of the votes for counting. The final batch did not arrive until 4 in the morning, even though the polls closed at 8 o'clock. So they brought it in and the ballots came in and no one knows where they came from. On November 5th, he claimed that 2 days after the election. On November the 20th, 3 days before the Michigan governor signed a certificate of ascertainment, noting the federal government that, based on the popular vote, Biden's electors were to represent Michigan voters. Defendant held a meeting in the Oval Office with the Speaker of the Michigan House of Representatives, the Majority Leader of the Michigan Senate. In the meeting, defendant raised false claims, among others, of illegitimate vote dump in Detroit. In response, the Michigan Senate Majority Leader told defendant that he had lost Michigan not because of fraud, but because the defendant had underperformed within certain voter populations of the state. Upon leaving the meeting, the Michigan House Speaker and Michigan Senate Majority Leader issued a statement reiterating this. The Senate and House Oversight Committees are actively engaged in a thorough review of Michigan's elections process, and we have faith in the committee process to provide greater transparency and accountability on our citizens. We've not yet been made aware of any information that would change the outcome of the election in Michigan. As legislative leaders, we will follow the law and follow the normal process regarding Michigan's elections, just as we said throughout the election. On December the 1st, the defendant raised the Michigan vote dump claim with the Attorney General, who responded that what had occurred in Michigan had been normal vote counting process and there was no indication of fraud in Detroit. Despite this, the next day, the defendant made a knowingly false statement that in Michigan, at 6:31 in the morning, a vote dump of 149,772 votes came in unexpectedly. We were winning by a lot. That batch was received in horror. No one knows anything about it. It's corrupt. Detroit's corrupt. I have lots of friends in Detroit. They know it, but Detroit's totally corrupt. On December the 4th, co-conspirator 1 sent a text message to the Michigan House Speaker reiterating his unsupported claim of election fraud and attempting to get the Michigan House Speaker to assist in reversing the ascertainment of legitimate Biden elections, stating, "Looks like Georgia may well hold some factual hearings and change certification under Article 2, Section 1, Clause 2 of the Constitution. As co-conspirator explained, they just don't have the right to do it, but the obligation. Help me get this done in Michigan." Similarly, on December 7th, despite still having established no fraud in Michigan, co-conspirator 1 sent a text intended for the Michigan Senate Majority Leader. So I need you to pass a joint resolution for the Michigan legislature that states that the last election is in dispute. There's an ongoing investigation by the legislature, and the electors sent by the governor are not the electors of the state of Michigan and do not fall within the safe harbor deadline of December the 8th. I mean, is this just petitioning your government from redress of grievances? You know, On December the 14th, the date the electors in states across the country were required to vote and submit their votes to Congress, the Michigan House Speaker and Michigan Senate Majority Leader announced that, contrary to Democrat requests, or defendants' requests rather, they would not decertify the legitimate results or elections of Michigan. The Michigan Senate Majority Leader public statement included, "We have not received evidence of fraud on a scale that would change the outcome of the election in Michigan." The Michigan House Speaker's public statement read, in part, "We've diligently examined these reports of fraud to the best of our ability. I fought hard for President Trump. No one wanted him to win more than me. I think he's done an incredible job, but I love a republic too. I can't fathom risking our norms, traditions, and institutions to pass a resolution retroactively changing the electors for Trump simply because some think there may have been enough widespread fraud to give him the win. That's unprecedented for good reason. There's why there's not enough support in the House to cast a new slate of electors. I fear we'd lose our country forever. This truly would bring about mutually assured destruction for every future election in regards to the Electoral College, and I can't stand for that. I won't." On January 6, 2021, the defendant publicly repeated his knowingly false claim. All right, I need a break from reading the document, so I will reactivate chat and see what's going on there. How are you guys doing in chat? You having fun? How are you all doing? What do you think so far? Do you think it's good? Do you think it's bad? Well, let's do it this way. On a scale of 1 to 10, how good do you think it is? Where 10 is Trump toastio, and 1 is I've seen better things written by Thomas Binger. So on a scale of 1 to 10, where 1 is I've seen better things written by Thomas Binger, and 10 is Trump toastio, where do you think this falls so far? What is your opinion? There was beef fish posting? Excellent. We had some haters, but they're gone. Also excellent. 1, 6, 5, 1, 1, 1, 1, 1, 1. Messed up 2, but they wanted 10. 1, 5, 6, 1. 1 should be a ham sandwich. I liked my example better. 1, 1, 3, 2. S'mores are good. E plus pi divided by 3-ish. Well, I know e to the I pi is -1. What's e plus pi divided by 3? Well, let me think. E is 2.718 and pi is 3.14. So that is, okay, I can do this. 3 plus 2 is 5. 1 plus 7 is 8. So that's 5.8. 4 plus, no wait, 2718. So 7 plus, so it's like 6. So it's roughly 2. It's very confusing too. Okay. I think I got there eventually. E is 2.718, right? And pi is 3.14. So what is 3.14 plus 2. Was 3.14 plus 2.71. 5, 8, 5. 585 divided by 3. So a little bit less than 2. Great. All right, fantastic. 1, 1, 2, 2, 3, 3, 1, 1, 2. 1, 1, 2 to 3, 2.7, 1, -5. Oof. You hit the button, that's great. 1, 2, 10 out of 10. Is all information supposed to be included in indictment? No, not necessarily. No. You don't need everything. You just need everything to prove, kind of get your standard of proof, and which in this case you would imagine to be more thorough than most. But you don't need everything in indictment. No. 3, 5 pi. -1,000. Criminalization of redress of grievances. Protect speech and question the official narrative. 42. 42 is good. 3.1415926. Yeah, well, 9265. Yeah. 314159265. 358979323. 84626 43383 27950 28841 39937 51058 20974 20841 97169. But who's counting? Anyways, the Chief stands alone. 5.85 to 2.95 1 1 1 1 1 2 1 5 6 1 1 3 1 2 1 -5. All right, we got all kinds of fun votes in here. All kinds of fun votes. Yeah. Good times. All right, let's check out, see what else we've got going on. No improv this week, Chris. So I'm happy to be here with you. All right, let's see what else we got. All right, let's get back to it. I'm glad to be here with the chat in general. I like the chat in general. Let's see what else is going on. Let's get back to it. Pennsylvania, November 11th, 2020, defendant publicly maligned the Philadelphia City Commissioner for staying on the news. There was no evidence of widespread fraud in Philadelphia. As a result, the Philadelphia City Commissioner and his family received death threats. But he's allowed to make statements, remember? On November 25th, the day after Pennsylvania governor signed a statement of ascertainment and thus certified the federal government that Biden's electors were legitimate, co-conspirator 1 orchestrated an event at a hotel in Gettysburg attended by state legislatures. Co-conspirator 1 falsely claimed that Pennsylvania had 1.8 million legislatures. I apologize. What did I say? 1.8 million absentee ballots and received 2.5 million in return. In their days thereafter, campaign staffer wrote internally that co-conspirators' one allegations were just wrong and there's no way to defend them. Deputy campaign manager responded, "We've been doing this for a while. It's very frustrating." On December the 4th, after 4 weeks of 4 Republican leaders of the Pennsylvania legislature issued a public statement that the Georgia Assembly lacked the authority to overturn popular vote and appoint its own slate of electors. Doing so would violate the state election code and constitution. Defendant retweeted a post labeling the legislator cowards. On December 31st and January 3rd, defendant repeatedly raised with the acting attorney general and acting dependent deputy attorney general the allegation in Pennsylvania there had been 205,000 more votes than voters. Each time the Justice Department officials informed the defendant the claim was false. On January 6th of 21, defendant publicly repeated his knowledgeably false claim there had been more than 205,000 false voters in Pennsylvania. In Wisconsin, I mean, this just seems like, just so much whatever, yeah, so much whatever. were we? On December the 14th, the Wisconsin Supreme Court rejected an election challenge by the campaign. One justice writing, "Nothing in this case casts any legitimate doubt. The people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our great country." On December 21st, a result of the state's Supreme Court decision, the Wisconsin governor, who had signed a certification of ascertainment on November 30th identifying Biden's elections as state's legitimate electors, signed a certification of false final determination in which he recognized the state Supreme Court had resolved the controversy regarding appointment of Biden electors and confirmed that Biden had received the highest number of votes in the state and the electors were state's legitimate electors. That same day, in response to a court decision that prompted the Wisconsin governor to sign certification and final determination, the defendant issued a tweet repeating his knowingly false election claim and demanding that the Wisconsin legislature overturn the election results that led to ascertainment of Biden's elections as the legitimate electors. On December the 27th, the defendant raised with the acting attorney general and acting deputy attorney general a specific fraud claim. There had been more votes than voters in Wisconsin. The acting deputy attorney general informed the defendant that the claim was false. On January 6, 2021, the defendant publicly repeated knowingly false claims that there had been tens of thousands of unlawful voters in Wisconsin. The defendant's use of dishonesty, fraud, and deceit to organize fraudulent slate of electors and cause them to transmit false certifications to Congress. All right, so we've moved out state-specific stuff with the lobbying of state officials, and we're going to try to go to this idea that he was in some way trying to get these false slates of electors appointed. So we're going to give that a bit of a shot for a second. As defendants attempted to obstruct the electoral vote through deceit of state officials met with repeated failure, beginning in early December 2020, he and his co-conspirators developed a new plan to marshal individuals who would serve as defendants' electors. Had won the popular vote to 7 target states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, and caused those individuals to make and send to the vice president and Congress false certifications that they were legitimate. Okay, so you think that Trump himself did this? I'd like to see where Trump's involvement is in this. This will be interesting. Under the plan, the submission of these false slates would create a fake controversy at the certification proceeding and position the vice president presiding on January 6th as president of the Senate to supplement legitimate electors with defendants' fake electors and certify the defendant as president. The plan capitalized on the idea presented in a memorandum drafted by co-conspirator 5, an attorney who was assisting defendants' campaign with legal efforts related to recount in Wisconsin. The memorandum evolved over time from a legal strategy to preserve defendants' rights to a corrupt plan to subvert the federal government function by stopping Biden electors from being counted and certified as follows. The November 18th memorandum advocated that because of ongoing recount in Wisconsin, the defendant electors there should meet and cast votes on December 14th, the date the Electoral Count Act requires appointed voters to vote, to present an alternative defendant's Wisconsin elector slate in the event the defendant ultimately prevailed in the state, which does sound a little bit similar to what that one case in Hawaii was all about, when there was competing slates of electors and casting them with the potential idea of being there for reserve. So there's some precedent, although in the case of Hawaii, there was issues dealing with, perhaps none of them were, perhaps there was no idea of what was going on. So maybe it's difference in kind in some ways, but all the rest of it. The December 6th memorandum marked a sharp departure from co-conspirators' Wisconsin memorandum, advocating that the alternative electors originally conceived of to preserve rights in Wisconsin instead be used in a number of states as fraudulent electors to prevent Biden from receiving the 270 electoral votes necessary to secure the presidency on January 6th. Okay, that's all very cool. The federal election memo suggested defendants' electors in 6 purportedly contested states, Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin, should meet and mimic as best as possible the actions of legitimate Biden electors, and that on January 6th, the vice president should open up and count the fraudulent votes, setting up a fake controversy that would derail the proper certification of Biden as president-elect. Okay. All right. The December 9th memorandum consisted of co-conspirator five's instructions on how fraudulent electors could mimic legitimate electors in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin. Co-conspirator five noted that in some states it would be virtually impossible for the fraudulent electors to successfully take the same steps as legitimate electors because state law required formal participation in the process by state officials or access to official resources, which, fair enough to be sure. The plan began in early December. Ultimately, the conspirators and defendants campaign took the Wisconsin memo and expanded it to any state defendant claimed was contested, even New Mexico, which defendant had lost by more than 10% of the popular vote, which I suppose doesn't necessarily preclude it from being contested in principle, but okay. I want to know at what point you stop calling a state contested, I guess. Maybe there's some magic number where there's a threshold. I don't know about how that's supposed to work exactly, but fine. Okay. Just by the way, just a brief shout out to our moderators as always. I'm sure they're still there in the chat floating around. I just want to say we appreciate their efforts as always to try to keep the chat a nice civic place. It's always appreciated. On December 6th, defendant and co-conspirators 2 called up the chairwoman of the Republican National Committee to ensure the plan was in motion. During the call, co-conspirator 2 told the chairwoman it was important for the RNC to help defendants' campaign gather electors in target states, and falsely represented her that the elector votes would only be used if ongoing litigation in one of the states changed the results. After the RNC consulted the campaign and heard work on gathering electors was underway, she called and reported this information to defendant, who responded approvingly, which, okay. So these are only slates that will be used in the event that we need them. Okay. On December 7th, co-conspirator 1 received the Wisconsin memo and fraudulent elector memo. Co-conspirator 1 spoke with co-conspirator 6 regarding attorneys who could assist in fraudulent electors' efforts in target states, and received from co-conspirator 6 an email identifying attorneys in Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin. The next day, on November the 8th, co-conspirator 5 called in the Arizona attorney on co-conspirator 6 list. In an email after the call, the Arizona attorney recounted his conversation with co-conspirator 5 as follows. I just talked to the gentleman who did that memo. Co-conspirator 5. His idea is basically that all of us, Georgia, Wisconsin, Arizona, Pennsylvania, etc., have our electors send in their votes, even though the votes aren't legal under federal law because they're not signed by the governor. So members of Congress can fight about whether they should be counted. They could potentially argue that they're not bound by federal law because they're Congress and they make the laws. Okay. Kind of wild creative. I'm happy to discuss it. My comment to him was, I guess there's no harm in it, legally at least. We'd just be sending in quote unquote fake electoral votes so someone in Congress can make an objection when they start counting votes and start arguing the fake votes should be counted. They use that is not particularly helpful as a way of phrasing that. That sounds kind of incriminating. So please do not write memorandums like this in the future, people. That's not good news. At co-conspirator 1 direction on December 10th, co-conspirator 5 was sent to points of contact in all target states except Wisconsin, which already received his memo. $5 from Jason Lizotte. Thank you, Kurt. Appreciate your ability to help us non-lawyers learn and have a better understanding of the documents. Well, thank you, Jason. Your super chat is appreciated. Co-conspirator 5 sent points of the contact to all target states except Wisconsin, which already received memos, and New Mexico streamlined version of the Wisconsin memo, which did not reveal the intended fraudulent use of the electors and the fraudulent elector instructions, along with fraudulent elected certificates that had to be drafted. The next day, still want to know how Trump is specifically related to this. Is Trump part specifically of this? Because they say, like Trump, is that all we have? Is because earlier they say they reported it to the defendant who responded approvingly, so that makes him part of the conspiracy? Oof. I hope they have more to drag him in than one thing like this. I hope they have more to drag him into a criminal conspiracy, man, than just like he was called by the RNC chairman and heard that this was kind of going. Like, okay, that sounds like a good idea. If that's their only tie they have to the conspiracy, man, I mean, that is some thin sauce, man, for a conspiracy, right? That's some thin sauce for a conspiracy. The next day, on December 11th, through co-conspirator 5, co-conspirator 1 suggested that the Arizona lawyer file a petition for cert in the Supreme Court as a pretext to claim that litigation was pending in the state to provide cover for convening and voting the defense fraudulent electors. Co-conspirator 5 explained to co-conspirator 1 had heard from a state official in state provisional election it could appear treasonous for Arizona electors to vote on Monday if there's no pending court proceeding. I don't know about treasonous, but dumb. To manage the plan in Pennsylvania on December 12th, co-conspirator 1, co-conspirator 5, co-conspirator 6 participated in a conference call organized by defense campaign with defendants electors in the state. While defendant electors expressed concern about signing certificates representing themselves as legitimate electors, co-conspirator 1 falsely asserted them the certificates would be only used if the defendant succeeded in the litigation. Subsequently, co-conspirator 6 circulated proposed conditional language to the effect for potential inclusion in certificates. A campaign official cautioned not to offer the conditional language to other states because the other states are signing what he prepared. If it gets out we're changing the language for Pennsylvania, it could snowball. In some cases, defendants electors refused to participate in the plan. On December 13th, co-conspirator 5 sent co-conspirator 1 an email memorandum that further confirmed the conspirators' plan was not to use fraudulent electors only in the circumstance that defense litigation was unsuccessful in one of the target states. Instead, the plan was to falsely prevent the slates as alternative to legitimate slates at congressional proceedings. And we're trying to bring Trump into this from this one conversation he had. On December 13th, the defendant asked senior campaign advisor for an update on what was going on with the elector plan and directed him to put out a statement on the electors. As a result, co-conspirator 1 directed the senior campaign advisor join a conference call with him, co-conspirator 6 and others. When the senior campaign advisor related these developments in text messages to the department deputy campaign manager, the senior advisor to the defendant and campaign staffer, the deputy campaign manager responded, "Here's the thing, the way that this had morphed into a crazy plan, so I don't know who wants to put their name on it." The senior advisor wrote, "certifying illegal votes." In turn, participated in the group text message refused to have their statement returning elections attributed to their names because none of them could stand by it. Also on December 13th, at a campaign staffer request, co-conspirator 5 drafted and sent fraudulent election certificates for the defendants electors in New Mexico, which had not previously been among the target states in which there was no pending litigation. The next day, defense campaign filled out an election challenge suit in New Mexico at 11:54 a.m., 6 minutes before the noon deadline for the elected votes as a pretext, so there was pending litigation at the time the election voted. That's interesting. That's very interesting. Braxton Heaps gave $5 to say, "Thank you for all the amazing content. Times are tough, but you're strong and we'll get through it." Well, thank you. As I mentioned recently, I've been dealing with a depressive episode recently. I seem to be on the way up about it, but I appreciate everyone who helps to support me as I deal with stuff and try to make sense of all this and trying to look for whatever value this has, which I'm not overwhelmed at this point. Excuse me, as it relates to Trump. Now, as it relates to, for example, these other co-conspirators, maybe, right, that they filed this election challenge 6 minutes before on a pretext so there was pending litigation. Like maybe there's something there for one of the co-conspirators, but how are we getting to Trump? Because he, in an offhand remark to the RNC chair, said, "Yeah, these alternative electors seem like a good idea," and so he's involved in a criminal conspiracy. I think you need a little bit more, man, than that to bring you into a criminal conspiracy. I hope you need a little bit more than that to bring you into a criminal conspiracy. On December the 14th, legitimate electors of all 50 states and the District of Columbia met in their respective jurisdiction to formally cast their vote for president, resulting in a total of 232 votes for the defendant and 306 for Biden. The legitimate electoral votes that Biden won the states defendant targeted and defendant's margin of defeat were as follows. And then they go through the specifics, which we don't need to. Well, we'll read them. Arizona, where there was 10,000 votes separating it. Georgia, 11,000 votes. Michigan, 154,000 votes. Nevada, 33,000 votes. New Mexico, 99,000 votes. Pennsylvania, 80,000 votes. And Wisconsin, 20,000 votes. Some of these are really tight. I mean, Arizona, Georgia, and Wisconsin are all 20,000 votes or less. That's pretty tight, you know? So like, so if he had won Arizona with 11, Georgia was 16, so that's 27, Wisconsin 37, that would have brought him to 269, which is that enough to win, or is that a tie in the Electoral College? Well, it's 538. What's half of 538? 219. What's half of 538? Well, half of 540 is 270. So it's 269. So yeah, if he had won those states, it would have been a tie. So I mean, all he needed was 40,000 more votes, and it would have been a tie. In which case, he would have won. So, yeah, I mean, how close was that election, right? In those states, yeah. Thank you for the gift memberships, by the way. For all those who are gifting gift memberships, appreciate it. Let's see, where was I? On the same day, at the direction of defendants and co-conspirator one, fraudulent electors convened sham proceedings in 7 target states to cast fraudulent electoral ballots in favor of defendant. In some states, in order to satisfy legal requirements set forth for legitimate electors, state officials were enlisted to provide fraudulent electors access to state capitol buildings so they could gather and vote there. In many cases, however, as co-conspirator 5 had predicted, in the fraudulent elector instructions, the fraudulent electors were unable to satisfy legal requirements. Nonetheless, as directed in the fraudulent election instructions, shortly after fraudulent elections met on December the 14th, the target states' fraudulent election certificates were mailed to the President of the Senate, the Archivist of the United States, and others. Okay. Defendant and co-conspirators ultimately used the certificates of these fraudulent electors to deceitfully target the government function, so contrary to how the fraudulent electors were told they'd be used. Again, you're not really getting to the defendant. You're not really getting to Trump. These other people may be, right, in getting these things together and sending them to these people, right? And maybe you're getting to some sort of fraud there. But Trump's connection to this is pretty attenuated, because how is Trump being part of this? Other than the one call with the RNC chair where he's like, yeah, these alternative electors are a good idea. Did he know about all this? Did he even know that any criminality was occurring? It's not clear from the way it's charged that that's true. So, I mean, unlike those fraudulent electors consistent with the Electoral Count Act, the legitimate electors' signed certificates were annexed to the state's executive certificates of ascertainment before being sent to the President, Senate, and others. So, they were obviously different in kind. That evening at 6:26 p.m., the RNC chairwoman forwarded to the defendant, through his executive assistant, an email entitled Electoral Recap Final, which represented then 6 contested states: Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin. Defendant's electors have voted in parallel to Biden's electors. The defendant executive assistant responded, "It's in front of him." It's not really clear to me that Trump knew or would have reason to suspect that this was illegal. I mean, some of these other people do, but Trump's a little bit too attenuated from this. He's just like, okay, so it would be a good idea if there were alternative electors, and alternative electors indeed, in fact, participated. So, from Trump's point of view, does he necessarily know that that's illegal? You normally require more for a conspiracy. You have to have some idea that, there's some illegality going on about it. Luke just sends me an email just now to let me know that he's enjoying my content. Well, thank you for your email just now. I will read it in more detail later. Thank you, Luke. Defendants attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors. Before we press on again, I'll take another look at the chat stream because I haven't looked since we've been reading before. So what else is going on in chat, and making sure that I haven't missed anything that is going on. Jason says, I'm dealing with complex PTSD and depression, and I understand. Thank you for sharing. Your videos help me keep looking forward in a positive state. You're the master at your gift. Well, thank you. And I'm getting better with every day. And I appreciate everyone who supports me. I appreciate your chat and your support and love. Lisa B gifted a whole bunch of gift memberships. I don't remember if I acknowledged you specifically or not before. And if not, I'll acknowledge you now. Thank you very much for your gift memberships. And thank you, Rose, for being here as a moderator. I appreciate that you're here helping to keep everything in good order. Let's see what else. Joseph says, I forgot what a scumbag Trump was during this period. He make Al Gore 2000 look like a patriot. That's a reasonable opinion. I mean, fair enough. He was being a very whiny person. That said, it being a scumbag isn't a crime. Luckily for official Washington. Well pointed out. And Lisa B gifted 20 gift memberships. So if I missed you earlier, thank you, Lisa, for your gift memberships. They are appreciated. Let's see. Yeah, they have nothing to time to January 6th. I think that's kind of the problem. They're looking for something to try to go about it a different way when they don't really have anything. So Braxton Heaps became a member. Thank you for hitting the join button. Appreciate it. The moderators are indeed the best. We do love them. Thank you for always. Best mods, for sure. Oh, MLS rated us earlier. Well, thank you, MLS, for rating us. Sorry I missed the notification, but thank you for joining us. I haven't been looking at chat so that I could remain focused on the stuff, but thank you for rating earlier, and I'm sorry I missed your earlier raid notification. Thank you for joining us. All right, let's see what is going on. Oh, there was a sticker earlier too from Chris. Sunglasses perpetually falling onto game controllers, proud face. Well, thank you for the sticker. Sorry, I didn't get that notification. Stickers, no, I don't think they show up in the stream chat. So thank you. I'm glad I saw that. All right, let's turn off the chat again and get back to reading some more. All right, chat is now off. Let's read some more. Defendants attempt to leverage Justice Department to use deceit to get state officials to replace legitimate electoral votes with defendants. In late December 2020, defendant attempted to use Justice Department to make knowingly false claims of election fraud to officials in target states through a formal letter under acting attorney general's signature, thus giving defendants' lies the backing of the federal government and attempting to improperly influence the target states to replace legitimate buying electors with defendants. On December 22nd, defendant met with co-conspirator 4 at the White House. Co-conspirator 4 had not informed his leadership at Justice Department of the meeting, which was a violation of the Justice Department's written policy restricting contacts with the White House to guard against improper influence. On December 26th, co-conspirator 4 spoke with the phone with the acting attorney general and lied about the circumstances of the meeting with defendant at the White House, falsely claiming that the meeting had been unplanned. The acting attorney general directed co-conspirator 4 not to have unauthorized contacts with the White House again, and co-conspirator 4 said he would not. The next morning on December 27th, contrary to the acting attorney general's direction, co-conspirator 4 spoke with the defendant on the defendant's cell phone for nearly 3 minutes. That afternoon, the defendant called the acting attorney general and acting deputy attorney general and said, among other things, "People tell me co-conspirator 4 is great. I should put him in." The defendant also raised multiple false claims about election fraud, which the acting attorney general and acting deputy attorney general refuted. When the acting attorney general told the defendant that the Justice Department could not and would not change the outcome of the election, the defendant responded, "Just say the election was corrupt and leave the rest to me and Republican congressmen." On December 28th, co-conspirator 4 sent a draft letter to the acting attorney general and acting deputy attorney general, which they proposed they sign. The draft was addressed to state officials in Georgia, and co-conspirator 4 proposed sending a version of the letter to election officials in other states. The proposed letter contained numerously knowingly false claims about the election of the Justice Department, including that the Justice Department had identified significant concerns that may have impacted the election in multiple states. The Justice Department believed that Georgia and other states, 2 valid slates of electors, had gathered at a proposed location December 14th, and that both sets of ballots had been transferred to Congress, which doesn't seem like something the Department of Justice would opine on, to be honest, because that's in Congress's role. I don't think that the Justice Department would opine as to whether or not the valid slates of electors have met or not. Another gift membership, JTF gifts 5 gift memberships. Thank you very much for the gift memberships, and thank you for everyone who hits that beautiful, beautiful join button. The Justice Department urged that state legislatures convene a special legislative session to create an opportunity through, among other things, choose fraudulent electors over legitimate electors. That doesn't seem like something the Justice Department would also write on, because it's up to the states to choose that. So the Justice Department urging the state legislatures to do that seems a little like not within the Justice Department's wheelhouse. So I can see why the Justice Department's not really thrilled about this idea. The acting deputy attorney general promptly responded to co-conspirator 4 by email and told him the proposed letter was false, writing that despite dramatic claims to the contrary, we've not seen the type of fraud that calls into question the reported and certified results of the election. In a meeting shortly thereafter, the acting attorney general and acting deputy attorney general again directed co-conspirator 4 not to have unauthorized contact with the White House. On December 31st, defendants summoned to the Oval Office the acting attorney general, acting deputy attorney general, and other advisors. In the meeting, the defendant again raised claims about election fraud Justice Department officials already had told him were not true, and senior justice officials reiterated were false and suggested he might change leadership in the Justice Department. On January 2nd, 2021, just 4 days before Congress's certification proceedings, co-conspirator 4 tried to coerce the acting attorney general and acting deputy attorney general to sign and send co-conspirator 4 a draft letter which contained false statements to state officials. He told them the defendant was considering making co-conspirator 4 the new acting attorney general, but co-conspirator 4 would decline the defendant's offer if the acting attorney general and acting deputy attorney general would agree to send the proposed letter to target states. Justice Department officials refused. Well, I mean, the president has the power to make appointments. So, but this is, right, this is just like what Nixon did, basically, by firing, everybody and until he found someone he liked, which was a big scandal at the time. With that, what was called Bloody Saturday or Bloody Sunday. Forget exactly what it was called, but something like that, where he fired the attorney general and the deputy and assistant attorney general because he was pissed. And then that itself became part of the whole Watergate scandal. The next morning on January 3rd, despite having uncovered no additional evidence of election fraud, co-conspirator 4 sent to the Justice Department colleague an edited version of the draft letter to states, which included change from a previous claim the Justice Department had concerns to a stronger false claim that as of today, there's evidence of significant irregularities that might have impacted the outcome of the election in multiple states. Also, on the morning of January 3rd, co-conspirator 4 met with the defendant at the White House, again, without having informed senior Justice Department officials, and accepted the defendant's offer that he become the acting attorney general. On the afternoon of January 3rd, co-conspirator 4 spoke with a deputy White House counsel. The previous month, the deputy White House counsel informed defendant, there's no world, there's no option in which you do not leave the White House on January the 20th. Now, the same deputy White House counsel tried to dissuade co-conspirator 4 from assuming the role of acting attorney general. The deputy White House counsel reiterated to co-conspirator 4 that there had not been any outcome-determined fraud in the election, and if defendant remained in office nonetheless, there'd be riots in every major city in the United States. Co-conspirator 4 responded, well, deputy White House counsel, that's why there's an Insurrection Act. Woof. 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 Co-conspirator 4 is... Okay. Also that afternoon, co-conspirator 4 met with the acting attorney general and told him defendant had decided to put co-conspirator 4 in charge of the Justice Department. The acting attorney general responded that he wouldn't accept being fired by a subordinate, immediately scheduled a meeting with the defendant for that evening. On the evening of January 3rd, defendant moved for a briefing on an overseas national security issue with the chairman of the Joint Chief of Staff and other senior national advisors. The chairman briefed the defendant on the issue, which had previously arisen in December, as well as possible ways the defendant could handle it. When the chairman and another advisor recommended the defendant take no action because inauguration day was only 17 days away, and of course any course of action could trigger something unhelpful, defendant calmly agreed, stating, yeah, you're right, it's too late for us. We're going to give that to the next guy, which seems like kind of contrary to the Department of Justice's entire thesis, right? It's like defendant who's Trump on January 3rd is like, it's too late for us. So, okay, that seems all right. The defendant moved immediately from this national security briefing to a meeting the acting attorney general had requested earlier that day, which included co-conspirator 4, the acting attorney general, the acting deputy attorney general, the Justice Department's assistant attorney general for the Office of Legal Counsel, the White House counsel, deputy White House counsel, and a senior advisor. At that meeting, the defendant expressed frustration with the acting attorney general for failing to do anything to overturn the election results, and the group discussed co-conspirators 4's plan to investigate purported election fraud and send his proposed letter to state officials, a copy of which was provided to the defendant during the meeting. The defendant relented in his plan to replace the acting attorney general with co-conspirator 4, only when he was told it would result in mass resignations of the Justice Department and his own White House counsel. So he backed off the plan. So that's sort of, isn't that sort of undermining? That's sort of undermining like the whole thing. This is January 3rd, right? So on January 3rd, Trump's like, okay, it's over. Is that sort of undermining the Department of Justice's entire thesis? Okay. I'm confused. At a meeting in the Oval Office on the night of January 3rd, co-conspirator 4 suggested the Justice Department should opine Vice President could exceed his lawful authority during the certification process and change the election outcome. When the Assistant Attorney General for Office of Legal Counsel began to explain why the Justice Department should not do so, the defendant said, no one here should be talking to the Vice President. I'm talking to the Vice President, and ended the discussion. Oh, okay. All right. That's seems like Trump is behaving kind of reasonably. Maybe it's going to change here in a second, but okay. You know, this is yeah. And I apologize earlier if I was rude to Kestrel and Sandy. I was just simply a little frustrated, and I may have responded inappropriately, and I apologize because our mods are good mods, and I'm sorry if my words were unduly sharp. I was just trying to move on, and anyways, I apologize. So my bad. Does conspiracy require success or an attempt? It requires a substantial step in furtherance thereto. So it doesn't require it to be successful, but it requires a substantial step. But it has to be a conspiracy for an illegal thing, because if we conspire for a legal thing, then that's fine. So Yeah. Excuse me. On personal victory news, I'd just like to add that I did have a nice workout today. That was good. I lifted hold on, let me find the photo. I did well today. I did a total volume today, total amount lifted of 36,290.1 pounds. So, yay. Workouts are going well. Oh, I haven't closed down chat yet. And someone said some of the verbiage seems very close to hearsay. Yeah, that's okay though. At this point in the proceeding, hearsay is allowed at this point. It wouldn't be allowed in court, but hearsay is allowed for the purposes of indictment, right? Hearsay is the rule against hearsay is a rule of evidence in a court proceeding, and we're a little bit early in that process. So you can have hearsay in, for example, a search warrant, or you can have hearsay in, for example, an indictment, right? So if it's sufficiently reliable. So the mere fact it's hearsay isn't a problem. So yeah, so hearsay can be used if it's sufficiently reliable. And that also makes sense if you think about it logically, because as I mentioned in an earlier stream as well, when we think about the criminal process, we're looking for greater and greater levels of certainty as we progress along the line, right? So what you need, like for example, as an investigation opens, versus what you need to like do a search warrant, versus what you need for an indictment, versus what you need, versus what you need, versus what you need, versus what you need, right? At certain stages. So like you can have hearsay at an earlier stage, because at an earlier stage we don't require as much confidence. And so that the fact that the hearsay is unreliable, or not reliable enough to be used in court, is okay, because at an earlier stage we don't require as much reliability, if you think about it logically. So the very fact that we require less confidence allows us to use the evidence that is less reliable, because we're in a position where we're moving towards greater levels of certainty. So if that makes any sense. Good question though. Good question. And then says, but metrics should be in weights, reps, and sets. Well, as to that much, my friend, I will respectfully disagree and say I'm going to look to total volume, because it's a big number, and big number makes me happy. So 36,000, booyah. Booyah. All right, let me turn off chat and get back into the thing. Where is the button to turn off chat for me? Come on, turn off chat so I can get back into it. Great, let's get back into it. Defense attempt to enlist the vice president to fraudulently alter the election results. As the January 6th congressional certification proceeding approached, other efforts to impair, obstruct, and defeat the federal government function failed. Defendants sought to enlist the vice president to use his ceremonial role at certification to fraudulently alter the election results. Defendant used this by knowingly false claims of election fraud to convince the vice president to accept defendants' fraudulent electors, reject legitimate electors, or send legitimate electoral votes to state legislatures for review rather than count them. When that failed, defendant attempted to use a crowd of supporters that he'd gathered to pressure the vice president. You want to be real careful with that. You want to be real careful with that. Like the idea that a person can't have a rally, the idea that a person can't have a discussion and just be like, that you got to be real careful. Okay. This is all right. This better be good. On December 19, 2020, after cultivating widespread anger and resentment for weeks with his knowingly false claims, which was, we've pointed out repeatedly, is legal. Do we have to go back to the start of the document where they said it? Defendant urged his supporters to travel to Washington, tweeting, "Big protest in DC on January 6th. Be there, will be wild. Last time I checked, protest was legal." Throughout late December, he repeatedly urged his supporters to come to January 6th. Okay. You're allowed to protest the government, even if you are the government. So, on December 23rd, the defendant retweeted a memo titled Operation Pence Card, which falsely asserted the vice president could, among other things, unilaterally disqualify. Remember what you said earlier about the president being able to lie, or just anyone being able to lie? Do I have to go back? Can I do a split screen here and go back earlier and show you? Can I split this document and show this so I can go back without losing my place? I don't know. We'll just have to take my word for it. I don't want to lose my place. But they did say it earlier. On the same day, co-conspirator 2 circulated a 2-page memorandum outlining a plan for the vice president to unlawfully declare the defendant the certified winner of the presidential election. In the memorandum, co-conspirator claimed that 7 states had transmitted 2 slates of electors and proposed the vice president announce that because of the ongoing dispute in 7 states, there are no electors that can be deemed validly apportioned in the states. That's not even close to how that works under the Electoral Count Act, but okay. Next, co-conspirator 2 proposed steps that he acknowledged violate the ECA, advocating that in the end, Pence then gavels President Trump as reelected. Just 2 months earlier, on October the 11th, co-conspirator 2 had taken the opposite position. Right near the Constitution or the ECA provides the vice president discretion in counting electoral votes, or prohibiting him to take the discretion on his own. No, yeah. On several, I just like to point out again, just the obvious. If the vice president could do this, it means Kamala Harris can do this. Do we really want Kamala Harris to have the legal right to get in there and just gavel whatever she wants? And be like, all these electors, these are invalid. I'm just going to refuse to accept them on my own. Joe Biden is president, or more to the point, me, I'm president now because I'm the captain now, right? Because whatever swings one way swings both ways, right? So if Pence has all this magical power, Kamala Harris has all this magical power. So I'm just saying, guys, remember it would go both ways. So I'm not sure that that's okay. I am sure actually that that's illegal. I am sure actually this is not a valid interpretation of the law. And no. On several private phone calls in late December and early January, defendant repeatedly false claims of election fraud and directly pressured the vice president to use his ceremonial role at the certification proceeding on January 6th to fraudulently overturn results of the election. And the vice president resisted, including on December the 5th, when the vice president called defendant to wish him a Merry Christmas. Defendant quickly turned the conversation January 6th and his request the vice president reject electoral votes that day. The vice president pushed back, telling defendants, as the vice president already done, I don't think I have the authority to change the outcome. On December 29th, as reflected in the vice president's contemporaneous notes, defendant falsely told the vice president that the Justice Department was finding major infractions. On January the 1st, the defendant called the vice president and berated him because he just learned the vice president had opposed a lawsuit seeking a judicial determination that at certification, the vice president had authority to reject or return the votes to the states. The vice president responded that he thought there was no constitutional basis for such authority and it was improper. In response, defendant told the vice president, "You're too modest." Within hours of the conversation, defendant reminded his supporters to be in Washington before the certification proceeding, tweeting, "The big protest rally in Washington, D.C. will take place at 11 a.m. on January 6th. Locational details to follow. Stop the steal." On January 3rd, defendant again told the vice president that at certification proceeding, the vice president had the absolute right to reject electoral votes and the ability to overturn the election. The vice president responded he had no such authority, and the federal appeals court had rejected the lawsuit, making that claim the previous day. Yeah, that's some bullshit. The vice president can't do this. And it's a good thing they can't. That's insane. That's insane. Right? On January 3rd, co-conspirator 2 circulated a second memorandum that included a new plan, which contrary to the Electoral Count Act, the vice president would send the electoral slates to the state legislature to determine which slate to count. Which isn't how that works, by the way. It's up to Congress to determine the validity. That doesn't make any sense. On January 4th, the defendant held a meeting with co-conspirator 2, the vice president's chief of staff, and Vice President's counsel for the purpose of convincing the Vice President, based on defendant's knowingly false claim of election fraud, the Vice President should reject or send the states to Biden's legitimate electoral votes rather than count them. Defendant deliberately excluded his White House counsel from the meeting because White House counsel previously had pushed back on defendant's false claims of fraud. During the meeting, as reflected in the Vice President's contemporaneous notes, defendant made knowingly false claims of election fraud, including, bottom line, won every state by hundreds of thousands of votes. We won every state, and like all of them? Really? Like Hawaii too? Just out of curiosity? Okay. And asked regarding his claim that senior Justice Department officials previously told him it was false, including as recently as the night before. What about the 205,000 votes more in PA than voters? Defendant and co-conspirator 2 then asked the Vice President to either unilaterally reject legitimate electors from the 7 target states or send the question of which slate was legitimate to the state legislatures. When the Vice President challenged the co-conspirator on whether the proposal to return the question states was defensible, co-conspirator 2 responded, well, nobody's tested before. The Vice President then told the defendant, do you hear that? Even your own counsel is not saying I have the authority. Defendant responded, that's okay. I prefer the other suggestion of the Vice President rejecting the electors unilaterally. This is not even close to right. This is not close to right. No. No. The president of the Senate is the presiding officer of the Senate, but he is bound by the rules of the Senate, because he's the presiding officer of the Senate. So the presiding officer doesn't have like magical power to just do whatever the hell they want. No presiding officer does. The presiding officer is bound by the rules, and it's up to the body to determine the legitimate interpretation of the rules. So it doesn't. This isn't how this works. It is not even close to how this works. This is stupid. This is stupid. Also, on January 4th, when co-conspirator 2 acknowledged, sorry. Let's see, where was I? Also, on January 4th, when co-conspirator 2 acknowledged to defense's senior advisor that no court would support his proposal, which, yeah, no duh. The senior advisor told the co-conspirator, you're going to cause a riot in the streets. Co-conspirator responded that there had previously been points in nation history where violence was necessary to protect the republic. Okay, refreshing the tree of liberty from time to time with the blood of patriots. Okay. After that conversation, the senior advisor noted that co-conspirator 2 had conceded his plan was not going to work. On the morning of January 5th, at defendant's direction, Vice President's Chief of Staff and Vice President's counsel met again with co-conspirator 2. Co-conspirator 2 now advocated that the Vice President do what defendant said he preferred the day before, unilaterally reject electors. During this meeting, co-conspirator 2 privately acknowledged to the Vice President's counsel that he hoped to prevent judicial review of the proposal because he understood it would be unanimously rejected by the Supreme Court. Yep. The Vice President's counsel expressed to co-conspirator 2 the following thought, though, with the proposal would result in a disastrous situation where election might have to be decided in the streets. Yeah, because you're doing something that's blatantly illegal, right? This is not even close to legal. It doesn't make any sense. The same day, the defendant encouraged supporters to travel to Washington on January 6th, and he set a false expectation the Vice President had authority to and might use his ceremonial role at the certification, proceeding to reverse the election outcome in the defendant's favor, including by issuing the following tweets. At 11:06, the Vice President has the power to reject fraudulently chosen elections. But as you pointed out earlier, and I keep having to mention it, you mentioned earlier he has the right to say lies. Right? Remember? You said that earlier. So if he's tweeting this, he has the right to tweet this. You said he does earlier. So, there's that. At 5:05 p.m., Washington is being inundated with people who don't want to see electoral victory stolen. Our country's had enough. They won't take any more. We hear you and we love you from the Oval Office. At 5:43 p.m., I'll be speaking at the Save America rally tomorrow on the Ellipse at 11 a.m. Eastern. arrive early, doors open at 7 a.m. Eastern, big crowds. Also on January 5th, the defendant moved to meet alone with the vice president. When the vice president refused to agree to the defendant's request that he obstruct certification, defendant grew frustrated and told the vice president defendant would have to publicly criticize him. Upon learning this, the vice president's chief of staff was concerned for the vice president's safety and alerted the head of the vice president's Secret Service detail. As crowds began to gather in Washington and were more audible from the Oval Office, defendant remarked to his advisors that the crowd the following day, on January 6th, was going to be angry. That night, the defendant approved and caused defendant's campaign to issue a public statement defendant knew from his meeting with the vice president only hours before was false. The vice president and I are in total agreement. The vice president has the power to act. What did we say earlier about your right to say false statements? Okay, hold on. All right, I gotta pull this up. Let me see if I can pull up the same document twice or something. Can I pull the same document twice or pull it up in a different window? Because I need to go back to what they wrote earlier. Hold on one second, please. See if I can open this up in a different window or something, because this is driving me a little bit crazy. All right, I can open it up in a Chrome tab and do it that way. So I just want to bring this paragraph again to your attention because I keep having to reiterate it, and it's becoming a little bit tiresome. Or at least it's like me having to point it out again, right? So we go back to earlier, right? The defendant has every right, like every American, to speak publicly about the election and even to claim falsely there had been outcome determined fraud during the election and he had won. He's allowed to speak falsely. He's allowed to speak falsely. The First Amendment protects falsehoods. So when you say that the campaign issued a public statement saying that we're in total agreement, he's allowed to speak falsely. It's protected First Amendment activity. Okay. On January 6th, starting in the early morning hours, defendant again turned to knowingly false statements aimed at pressuring the vice president to fraudulently alter the election and raised publicly the false expectation he might do so. Is he allowed to speak falsely or not, man? At 1 a.m., the defendant issued a tweet that falsely claimed, if the vice president at Mike Pence comes through for us, we'll win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it might be. Mike can send it back. Not true, but Donald Trump can say it. At 8:17 a.m., the defendant issued a tweet that falsely stated states want to correct their votes, which they now know to be based on irregularities and fraud, plus corrupt process never received legislative approval. All Mike Pence has to do is send them back to states and we win. Do it, Mike. It's time for extreme courage. On the morning of January 6th, an agent of defendants contacted a United States senator to ask him to hand-deliver documents to the vice president. The agent then facilitated the receipt by senator staff of the fraudulent certificates signed by defendants, fraudulent electors in Michigan and Wisconsin. So this is the defendant himself trying to do this. Is this where we're trying to bring him in now and say that the defendant had knowledge of the specific thing? I'm trying to give knowledge of the specific thing. So we're trying to do it that way. Okay. When one of the senator staffers contacted the staffer for the vice president by text message to arrange for delivery, what senator staffer had been told were alternate slates of electors for Michigan and Wisconsin because the archivist didn't receive them. The vice president's staffer rejected them. At 11:15 a.m., the defendant called the vice president again, pressured him to fraudulently return or reject the legitimate vote. The vice president again refused. Immediately after the call, defendants decided to single out the vice president in public remarks they'd make within an hour, reinserting language he had previously drafted earlier that morning, falsely claiming the vice president had authority to send the electoral votes back, but advisors had successfully advocated to be removed. He is allowed to speak falsely. It is a protected First Amendment right. The First Amendment protects lies. You're allowed to say false things. So we're trying to use protected First Amendment activity, it seems to me, and it's getting a little bit tiresome, to be sure. Mm. Earlier that morning, defendant had selected co-conspirator 2 to join co-conspirator 1 in giving public remarks before his own. When they do so, based on knowingly false claims, co-conspirator 2 and co-conspirator 1 intensified pressure on the vice president to fraudulently obstruct the proceeding. Co-conspirator 1 told the crowd the vice president could cast the ECA aside and unilaterally decide on the validity of these crooked ballots. He also lied when he claimed to have letters from 5 legislatures begging us to send elector slates to the legislatures for review and called for trial by combat. I missed the trial by combat line. That's pretty cool. Who are we combating just incidentally in this? Are we going to do like a Trump Biden trial by combat? Are we going to do seconds or something? We're doing this by pistols or by swords, or how's that going to work? I don't know. That sounds kind of, I don't know. I'm mildly intrigued by this idea. Co-conspirator 2 told the crowd, all we're demanding of the vice president, all we're demanding of the vice president is this afternoon at 1 o'clock, you let the legislature of the state look into this so we get to the bottom of this. American people know whether or not we have control of the direction of our government or not. We no longer live in a self-governing republic if we can't get an answer to this question. Slow your roll, my friends. Slow your roll. But they're allowed to say it, right? They're allowed to speak lies. The First Amendment protects lies. Good times. All right. Next, beginning at 11:56 a.m., the defendant made knowingly false statements integral to his criminal plans to defeat the federal government function, obstruct certification, and interfere with other rights to vote to have their votes counted. Defendant repeatedly false. Okay, Pony Up donated $10. He's allowed to speak against the results. That's the basis of the First Amendment. Also, didn't Pence have the authority to send back electors if they dual slates for recounts? No, not in my view. Not according to the Electoral Count Act. No, it's up to the Congress to determine if the slates are valid or not. But they don't have any authority that I'm aware of, and Pence certainly doesn't have any authority unilaterally to send it back. No, so Congress can challenge the legitimacy of a slate of electors, and they can choose to. And if there's competing slates of electors, they can choose which one to recognize. But Pence can't do it unilaterally, and I'm not aware of authority to send it back to the states. Like they can just like de-recognize a state, but I don't think they can send it back like that. I'd have to double check the Electoral Count Act, but that doesn't sound right. But thank you for your super chat and for your questions. Very, very kind of you in both cases. Next, beginning at 11:56 a.m., defendant made knowingly false statements integral to his criminal plans to defeat the federal government function, obstruct certification, interfere with others' rights to vote, to have their vote counted. The defendant repeated false claims of election fraud, gave false hope the vice president might change the election outcome, and directed the crowd in front of him to go to the Capitol as a means to obstruct the certification. I don't think so, man. Like, there's a difference between protesting and obstruction. Go to the Capitol and have your states heard is not obstruction. That's protest. And pressure the vice president to falsely obstruct the certification. Defendant knowingly false statements for these purposes include: defendant falsely claimed that based on fraud, the vice president could alter the outcome by stating, "I hope Mike is going to do the right thing. I hope so. I hope so. Because if Mike Pence does the right thing, we'll win the election. All he has to do, all this is from number one, or certainly one of the top constitutional lawyers in our country. He has the absolute right to do it. We're supposed to protect our country, support our constitution, support our constitution, and support our constitution. States want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back. All Vice President Pence has to do is send it back to the states to recertify, and we become president, and you're the happiest people." He's allowed to say some BS. After the defendant falsely stated that Pennsylvania legislature wanted to recertify the vote, they want to recertify, but the only way they can is if Pence agrees to send it back. The crowd began to chant, "Send it back." Defendant also stated that regular rules no longer apply, stating, and fraud breaks up everything, doesn't it? When you catch someone in a fraud, you're allowed to go by very different rules. Well, no, not really. No. A fraud doesn't like magically change like all the rules ever and put us into a completely new universe of things. and it doesn't necessarily completely even undo the thing in question. You can get to more nuanced questions depending on the nature of the fraud, what was defrauded, and some things like that. So like, it doesn't like magically put you into some new universe of rules. That's not a thing. Uh, yeah, no. Finally, after extorting that we fight like hell. If you don't fight like hell, you're not going to have a country anymore, which is very similar to things that politicians have said basically forever. The defendant directed the people in front of him to head to the Capitol, suggesting he was going to go with them, and told them, members of Congress, the kind of pride and boldness they need to take back our country. During after defendant's remarks, thousands of people marched towards the Capitol. Shortly before 1 p.m., the vice president issued a public statement explaining that his role as president of the Senate, as certification proceeding was about to begin, did not include unilateral authority to determine which electoral votes should be counted and which should not. Just give me 1 second. I need to check something. Give me 1 second. Um, okay, I'm. Oh yeah, I mean that's fine. Yeah, that's fine. Give me 1 second. I just want to respond to something real quick. Yeah. And just a shout out to my mods again. I want to give them a special mod out because I was a little bit rude earlier, and that was my fault because I lost my temper. And you know, when you make a mistake, you want to apologize, as one does. So just a shout out to my mods, in particular, Sandy, Rose, and uh, Sandy and Rose, and who else is here? Kestrel, I think, is still here. Appreciate you being here. And they do volunteer. And it's just all volunteer. And I appreciate that. Evil Coleslaw, thank you. All appreciate it. Yeah. So I just want to give a shout out to them. You know, it's all volunteer. There's never an expectation that they need to be here. One of the reasons that I have so many mods is to increase the probability that one of them will be available. But they've, you know, they're here and they show a lot of support. So they're really appreciated. Um, where was I? All right. The defendant's exploitation of violence at the chaos. Shortly before 1 p.m., the vice president issued a public statement explaining his role as president of the Senate as certification was about to begin, did not include unilateral authority to determine which electoral votes should be counted and which should not. I'm glad that you're here as well, Springstorm. Before defendant had finished speaking, a crowd began to gather at the Capitol. Thereafter, a mass of people, including individuals who traveled to Washington and Capitol defendant's direction, broke through barriers, quartering off Capitol grounds and advancing on the building, including by violently attacking law enforcement officers beginning to secure it. Defendant, who had returned to the White House after concluding his remarks, watched events at the Capitol unfold on television in a dining room next to the Oval Office. At 2:13 p.m., after more than 1 hour of steady, violent advancement, the crowd at the Capitol began to break into the building. Upon news that individuals broke into the Capitol, defense advisor told him there was a riot there and the rioters had breached the building. When advisors urged the defendant to issue a calming message aimed at the rioters, the defendant refused, insteadly repeatedly remarking the people of the Capitol were angry because the election had been stolen. At 2:22 p.m., after advisors had left the defendant alone in the dining room, the defendant issued a tweet to further delay and obstruct the certification by saying, Mike Pence didn't have the courage to do what he should have been done to protect our country. and our Constitution, giving states a chance to certify a correct state of facts, not the fraudulent or inaccurate ones they were asked to previously certify. USA demands the truth. 1 minute later, at 2:25 p.m., the U.S. Secret Service was forced to evacuate the vice president to a secure location. At the Capitol, throughout the afternoon, members of the crowd chanted, "Hang Mike Pence, where is Pence, bring him out, and traitor Pence." Defendant repeatedly refused to approve a message directing rioters to leave the Capitol, as urged by his most senior advisors, including the White House counsel, deputy White House counsel, chief of staff, deputy chief of staff, and senior advisor. Instead, defendant issued 2 tweets that did not ask rioters to leave the Capitol, but instead falsely suggested the crowd was being peaceful, saying at 2:38 p.m., "Please support our Capitol Police and law enforcement, but truly on the side of our country, stay peaceful." Which, okay. At 3:13 p.m., I'm asking everyone at the U.S. Capitol to remain peaceful, no violence. Remain, we are the party of law and order. Respect law. I'm not really sure that's necessarily a suggestion that they are being peaceful, as mostly a suggestion to restore to peace, but okay. Yeah. Yeah, Randall points out that there's 60 cases that basically fell apart. And I read about half of them and they were pretty trash. I read about half of them and they were pretty trash. So they were I didn't get too mad. There was one in there I remember reading. One I was like, okay, there might be something here, and the court kind of dismissed that out of hand too, which I didn't even blame them. I had to really reach to find one that was kind of not complete garbage. They were kind of bad. At 3:30 p.m., the defendant had a phone call with the minority leader of the United States House of Representatives. Defendant told the minority leader that the crowd of the Capitol was most upset about the election than the minority leader was. At 4:17 p.m., the defendant released a video message on Twitter that had just taped in the White House Rose Garden. In it, the defendant repeated the knowingly false claim that we had an election that was stolen from us. And finally, asked individuals to leave the Capitol while telling them that they were very special and we love you. After the 4:17 p.m. tweet, the defendant joined in the outer Oval Office to watch the attack on Capitol on television. The defendant said, "See, this is what happens when they try to steal the election. The people are angry. These people are really angry about that's what happens." At 6:01 p.m., the defendant tweeted, "There are things and events that happen when a sacred landslide election is so unceremoniously and viciously stripped away from great patriots who have badly and been unfairly treated for so long. Go home with love and in peace. Remember this day forever." On the evening of January 6th, defendant and co-conspirator 1 attempted to exploit the violence and chaos at the Capitol by calling lawmakers to convince them that based on knowingly false claims of election, delay certification, including defendant through White House aides attempted to reach 2 United States senators at 6 p.m. From 6:59 p.m. until 7:18 p.m., co-conspirator 1 placed calls to 5 United States senators and 1 United States representative. Co-conspirator 6 attempted to confirm phone numbers for 6 United States senators whom the defendant had directed co-conspirator 1 to call and attempted to enlist and further delaying certification. In one of the calls, the co-conspirator 1 left a voicemail intended for a United States senator that said, "We need you, our Republican friends, to try to just slow it down so we can get these legislatures more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so we can get ourselves in tomorrow, ideally the end of tomorrow." Another message intended for another United States senator, co-conspirator 1 repeated knowing false allegations of election fraud, including the votes certified by the states to Congress were incorrect, and the government who had certified knew they were incorrect. The illegal immigrants had voted in substantial numbers in Arizona, and that Georgia gave you a number in which 65,000 people who were underage voted. Co-conspirator 1 also claimed the vice president's actions had been surprising and asked the senator to object to every state and kind of spread this out a little bit like a filibuster. At 7:01 p.m., while co-conspirator 1 was calling United States senators on behalf of the defendant, White House counsel called the defendant, asked him to withdraw any objections and allow certification. The defendant refused. The attack on the Capitol obstructed and delayed the certification for approximately 6 hours until the Senate and House of Representatives came back into session separately at 8:06 and 9:02 respectively, and came together in joint session at 11:35. At 11:44, co-conspirator 2 emailed the Vice President's counsel advocating that the Vice President violate the law and seek further delay. Co-conspirator 2 wrote, "I implore you to consider one relatively minor violation of the ECA and adjourn for 10 days to allow legislators to finish their investigation, as well as to allow full forensic audit of the massive amount of illegal activity that occurred. I'm not sure that's a minor violation, a 10-day suspension, but okay. At 3:41 a.m. on January 7th, as President said, the Vice President announced certified results of the 2020 election in favor of Biden. The defendant and his co-conspirators committed one or more acts to effect the objection of the conspiracy as alleged above, in violation of law. Well, I have to say that a lot of this seems overwrought, thin, forced, not really on point, and just not really great as well. Yeah, I'm trying to. Babs says, "Great that you're reading the complaint, but please try to explain each paragraph as well." I'm trying to explain as necessary or as points need to be explained. I just find the overall thing a little bit thin, a little bit problematic, a little bit, just like not very good overall. And it seems forced, and President Trump's action in this seems forced to that as well. So it just seems a little bit overwrought. Count 2, the allegations are reported above. From on or about November 14th through about January 7th, Donald Trump did knowingly combine, conspire, confederate, and agree with conspirators, known and unknown, to obstruct the proceedings. Count 3, obstruction. Count 4, conspiracy against rights. And that is the end of the indictment, and thank God. I'm a little bit tired. All right, so my overall thing is I feel that it's just overwrought and thin, and there is at least to my mind, a conflation of legal action with illegal action in a way that I find a bit unsettling, especially as it relates to attorneys, because it reminds me of sort of like this lawyer's joke. It reminds me of sort of this like old tired lawyer's joke where a prosecutor threatens to indict a defense lawyer for accessory after the fact, because the defense lawyer, by acting as the defendant's lawyer, is aiding and abetting the defendant. And so they threaten the defense lawyer by the very act of being a defense lawyer with aiding and abetting and accessory after the fact. It's like this old lawyer's joke. This is what counts for an old lawyer's joke, right? So I apologize. It reminds me of that, right? It's like, the very thing that's making it legal is what makes it illegal. So it's just like, it's like tried and true, It's like, charge the defense lawyer with obstruction because you're preventing the government from convicting this guy because of all your objections. Let's charge you with obstruction, that kind of thing. So it just strikes me as very, very odd and very, very thin. So I don't really buy much of this as well. So my overall assessment is it's pretty BS. So I think that, the Mar-a-Lago document case remains the best. And this feels overwrought. And also, there's also a question that we haven't really spoken to as well, that because this happened while Trump was president, there's also sort of a latent constitutional question as to whether because the president's the head of the executive branch. See, that's the thing, right? Because he's head of the executive branch, that comes with all kinds of unique, interesting constitutional things. Like the president is different than anyone else in the executive branch because he's the president, right? He is the head. The executive branch shall be embodied in one president of the United States, right? Article 2, Section 1, right? And so the role of the president comes with these constitutional things that are distinct. The only one that arguably has any other constitutional protection is the vice president, because also they're mentioned in the Constitution. But the president's kind of unique in this respect. So there is a latent question which is completely unsolved here or completely unaddressed as to what degree, if any, the president can violate the law while he's president, because he's the one charged with the faithful execution of the laws. And so there is, I don't know the answer to this question, and it may be a bit of a silly question, but it's like, can the president commit a federal criminal violation while he's president? And or is it because there's, and also you get into the question of what the role of the presidency is, because to the extent that he's behaving, to the extent he is the president, then he gets absolute immunity, right? So he gets absolute immunity to the extent he's president. And because he's president, he gets everything the executive branch does, right? So trying to find how it's not within his role is really challenging. And this recently came up, for example, in a defamation suit, which I thought was kind of questionable, where it's like, well, Trump was acting outside his role when he did these things. And I'm like, I'm not sure about that for exactly the same reason. Because the president has like this, I mean, the president is Article 2. The president is an entire branch of government unto himself, because that's in the nature of the thing. He is an entire branch of government unto himself. So that comes with, a lot of things. He gets quasi-king-like powers. I mean, he's at least a third of the king. Like what a king is just unified legislative, judicial, and executive all rolled up into one, right? So we separated these powers out, but like he has some of this like quasi-king-like power because he is the entire executive unto himself. So it is it's in the nature of the thing. There's also a bit of a sovereign immunity issue there because he's the head of state. And so he is to some degree the sovereign, and there is issues with that as well. So it's like, you're like, can you prosecute the president for a criminal violation? Is not, there's something there. There's something there that needs to be teased out. Some more. So there's something that needs to be teed out more. So yeah. So that's interesting. Yeah, he's not empowered to create law. That's true. Like he does have his limitations. That's certainly for sure. He doesn't have the power to create law. That's true. But like some of this stuff is separating out his role as president from this is really challenging. Separating out his role from this is really challenging. How's immunity fall into this? I don't know. There's some issues for sure. It's going to be interesting trying to tease this out because this all happened while he was president, as opposed to the records case, right? As opposed to the classified records case, at which point he was no longer president, when which these concerns kind of go away. But the fact he's president at the time while this is happening raises some potentially interesting constitutional questions. What happened with Nixon in Hawaii? At the time, there were like two slates of electors because there was uncertainty, because there was no valid slate, right? There was no valid slate because it was being sort of like still debated. So there were two slates of electors for a while in Hawaii because there was no valid slate. So this one's a little bit different because there is a valid slate, but there's something there. It's interesting. All right. All right. Well, I think I'm going to sign off for now. That is a lot of legal analysis, and I'm pretty tired 3 hours in. So we will definitely be discussing this more in coming days, I would imagine. We'll be discussing this more in coming days, and I'm going to listen to some other people's commentaries and see if I can hear some other perspectives on this thing and try to get a more well-rounded perspective so that can say something more intelligent about the whole thing. Yeah. I'm going to send you over to Good Logic, who I imagine will have some different perspectives than me, but that's okay. He's wrong, but you can listen to him anyway if you want. So I'm going to send you over to Good Logic's chat. So be nice. Be nice. Okay. And just remember that Good Logic is trying to raise money for his son's wedding. So if you want to throw a couple bucks his way, a couple shekels his way, I'm sure he'd appreciate it to help defray some of the cost. All right, I'm going to send you over his way. Be nice. I've been on Civil Law. I'll talk to you later. Cheers, my friends, and goodbye.